Good morning. I hope you can be able to hear and see me clearly. Can I get a thumbs up in the chat? Okay, thank you very much. Welcome to day 2 of the Banking and Finance Symposium organized by the Uganda Law Society. My name is Belinda Patience Cheptowek, an associate with Signum Advocates, and I will be your MC again for today. So, yesterday, as you recall, we had very diverse discussions, and I believe we learned a lot, but maybe to just go through a bit of the things that we picked up from yesterday before we dive into today's program, which is also very rich. Yesterday, we had discussions on Islamic finance in Uganda, and we were demystifying commercial jurisprudence around Islamic finance. And we learned a lot, actually, from the speakers that were there yesterday. We understood that Islamic finance is not a preserve for Muslims. It's actually also can be enjoyed by non-Muslims, and all of us should look into that sector, especially those of us that are playing in the banking and finance area. We also learned that Islamic finance prohibits interest, excessive uncertainty, gambling, speculation, etc. The other key aspects that came through during the presentations was the fact that Islamic finance promotes profit and loss sharing mechanism. It also promotes partnership rather than debt mechanism. And it was interesting to also hear that even our Pope has actually approved of the no interest policy. We had several examples of where previous popes have recognized and even requested Western countries to adopt Islamic finance. So I'm very certain that at least from those deliberations, we have been able to understand a bit more than we knew on Islamic finance, and I hope it's something that we can be able to take up moving forward. But that wasn't the only thing that we discussed yesterday, if you recall. We also had a legal panel on the legal hot topics in the banking and finance sector in Uganda. We looked at ESG, we had discussions on AI, we had discussions on cybercrime, and a number of other emerging trends in the banking and finance sector. And one of the things that actually also came up clearly there is the fact that ESG compliance is now something that has taken shape in the world, and we have to pick up our pace, especially as Ugandans, playing in the banking and finance sector, to be able to advise our clients on how to navigate that ESG space. But also the fact that even ESG itself opens up our different clients to different forms of capital, because now most financials out there are looking at entities that are adhering to ESG requirements. Also, enables the clients by public goodwill. As you know, we are right now in an era of cancel culture. So if your client is not adhering to some of these things, social media will definitely have a say in, quote unquote, canceling that particular client. So I think we are able to learn a lot on how we can be able to navigate and how we can be able to give value addition to our respective clients, especially in that particular space. We also had a discussion on AI and technology. I think that is something that is now starting to take shape in this economy and across the world entirely. And we usually say that if you're not moving with the world, you're going to be left behind. And by the time you're playing catch up, things will have already moved forward. So we had panelists telling us that even if we don't have a law in place to regulate AI or to regulate even Bitcoin in Uganda, it's important for us as lawyers to skill ourselves and prepare our clients in the fintech space so that by the time we have some of these policies or some of these laws being rolled out, they are actually ready to participate in that space. But also us ourselves, we have skilled ourselves enough to the point that when these laws are being rolled out, we actually can be able to benefit from that particular space. The panelists indicated that we can, take part in different trainings that are organized even at the East African Law Society level that are touching on some of these aspects, because some of the countries that are within our region have moved forward in putting in place some of these laws. We also, moving past that particular discussion, we then delved into tax considerations in the banking and finance sector. And as I say, tax is something that affects all of us, whether it's you're using just, whether you're just buying things at your supermarket, whether you're dealing with, whether you're getting loans from financial institutions, whether you're making payments. It was actually interesting to understand the nitty-gritties that get into how the charges when we swipe our cards, whether it's at restaurants or bars, how those transactions actually play out, the Visa charges, because sometimes we just move ahead and swipe the cards and don't know how, the entire channel or the taxes, applicable taxes and charges. But it was interesting to have that discussion to actually understand that with Visa charges, you have, I know one of the panelists, Bruno Kalibala, indicated that we have VAT exemption for financial services, including payment and transfer of money. And in his opinion, he had indicated that actually that could also encompass Visa payments because it's a payment platform. So we also had discussions as well on Nostro accounts. I know there are a number of people who are also just interfacing with the aspect of Nostro accounts for the first time, but we understood and we had the regulator here telling us that with Nostro accounts, you have withholding taxes applying for both transactional and account management of those specific Nostro accounts. The bigger question then is who is responsible for withholding those taxes? They threw that question back to you, the audience members. I don't know if anyone has been able to research and find out the answer on who actually then withholds that money. Is it the individual that is requesting the local bank to make the transaction, or is it that local bank that is making the transaction that is supposed to withhold? I think we'll still have to engage more discussions in that particular aspect. And I think, of course, the one that came out also strongly, and something that we have seen happening, is the evolution of stamp duty fees when it comes to financial transactions in Uganda. The fact that now, we have a nil stamp duty for all borrowings, internal borrowings from our local banks in Uganda. And I think the main question, and that essentially, as our panelists indicated, Ms. Winnie indicated that really it's really to open up or promote more accessibility of finances to the different people. The bigger question, as she indicated, remains who is responsible for actually withholding and remitting that stamp duty. Is it the client? Is it the financial institution? Of course, she said that as of now, URA seems to indicate that the financial institution should be the one to actually remit that money. I think that is something also that is being discussed further. But that is just a recap of all the things that we had yesterday, which I think were very broad discussions and very engaging discussions. But today, we continue to have more robust discussions and into the different aspects of banking and finance. We are going to look at how do we perfect securities, what are the different types of security interests that we have in our market, and how can we be able to actually benefit from that particular sector. We are going to talk, again, an extensive discussion on AI and digitization in the banking and finance sector. We are going to have discussions on cross-border practice in banking and finance. And we shall also be talking project finance. What is project finance? How can we position ourselves to benefit from the project finance sector? Again, I, for one, am very elated and look forward to these discussions. But at this juncture, I will introduce our next presenter, who is with us already in the house. Her name is Linda Aine. Linda Aine is an advocate with SM and Co Advocates, which is formerly Shonubi Musoke and Co Advocates. She has previously worked with the Uganda Revenue Authority, and she has advised numerous local and international borrowers and lenders on the different financial transactions. So I know we will be able to learn a lot from her. She's going to present. Her presentation is on an overview of the various types of security interests, perfection processes, and enforcement under Ugandan law. Welcome, Linda. Yes, you can now take us through your presentation. Thank you.
Okay, thank you so much, Belinda. I believe I'm also being heard as well. Thank you for that recap. Anyone who wasn't here yesterday now basically has almost everything that was said. This is my second day as well. I attended yesterday, and I'd like to pass on my appreciation to the Uganda Law Society. We have really learned a lot in the few days, and I hope that you may learn from me as well. Yes. So to our online participants, we'd also thank you for joining in. Would appreciate if you would, in case I say anything that you agree with or that you disagree with, feel free to type in the chat. We'll be able to see those comments and respond. So my presentation is basically an overview on security interests in general. And security interests are so wide that, of course, it's not possible to cover each and everything in today's session, but I will do my best to basically hint on the important things. Why it's important, it may seem obvious, but it's actually not. As banking and finance practitioners, it's important that we refresh our minds and that we learn and unlearn certain things. Times are moving, and basically our work is centered around security interests. So it's important that we understand how they work, new developments, and things like that. So I'll dig right into it. Okay. Yeah, so the first question that we should have in mind is basically what a security interest is. So a security interest is basically a right that a creditor has over property that is either owned or in which a debtor has an interest. And this interest is by a security document to secure the payment of an obligation. So it's as simple as that, and we should keep that in mind going forward. Yeah, so security interests can take various forms, and we've tried to classify them into these four, though it can be broader than these. But I thought for the Ugandan economy and for a practitioner practicing in Uganda, these 5 forms of security would suffice. So the first one would be a charge. So a charge is basically an interest over property without necessarily transferring ownership right. So this can be in several forms. It can be over immovable property, that's where we have the mortgages. It can be over movable property, that is where we have motor vehicles. It can be over shares, and so on and so forth. So the list is endless. They can be over anything. Now a charge can be either fixed or floating. So for fixed charge, the asset's already ascertained at the time of creating the charge. For a floating charge, the assets will be ascertained at a later date. And that's basically the distinction, nothing peculiar about it. The other is an assignment, and that usually involves transfer of a right to receive proceeds. For example, this can be rental proceeds, insurance proceeds, and things like that. Then we also have guarantees, which is basically a contractual undertaking by one party to secure a debt of a third party. Then we also have possessory security interests. So this is where we have pledges and liens. So this basically, in contrast to charges where you don't actually take possession, this involves where you actually have possession of the actual asset being charged. Now, the main difference between the two, I mean, you might wonder why a pledge is different from a lien. The best example I can give of a lien is if you, for example, take your car for repair and then you fail to pay. So the mechanic can then have a lien over the car. So a lien is created not as security first, but for some other purpose that is not security. Whereas for a pledge, it is created for security first. Now we have certain, and we've seen them in our practice, where we fail to distinguish between, for example, share pledge and a share charge. Strictly speaking, although at common law, they refer to them as share charges. Strictly speaking, you cannot have, at common law they refer to them as share pledges. Strictly speaking, you cannot possess a share, so you cannot create a pledge over it. So over time, in our practice, we have resolved to call them share charges because, it's the most appropriate thing to call it. Though another person may argue that if I deposit my share certificate with a lender, then doesn't that mean it's possessory? And my answer to that would be no, I don't think it is, because then that would mean that if I deposit my land title, then you have possession of it. Yeah, so that's basically the distinction between the two. Yeah, so there are various forms of security documents. They don't take only the forms I mentioned there, but these are the common ones. Mortgage deeds, those are over immovable property. Land, we have debenture deeds, which are basically an acknowledgement of debt by a company. It can be over a class of assets, or it can be over a single asset. They can take various forms, basically. Then we also have deeds of assignment. Basically, like what I said, assigning a right to a debtor, share charges, as I've already said, guarantee deeds. So these are a no-brainer. Yeah, so as practitioners, there are certain considerations that we should take into account when we're advising our clients and also when we are drafting security documents. Yeah, so the most basic is basically the applicable law. And this is determined, one, by the jurisdiction, that is where the collateral is going to fall. Two, by the nature of the asset itself. And why this is important is because, we've seen various cases whereby security documents are challenged for non-compliance with the law. I'll give you an example. If it's a mortgage, the appropriate thing would be to, conduct due diligence, find out whether it's matrimonial property, whether it is leased property, whether any consents are required, be it spousal consent, lessor's consent, anything. Then, more specifically, there are also specific sector laws that would be important for creation of security interests in particular assets. I'll give you an example. If the charged asset is let's say a mining license, then there is a requirement to obtain the consent from the Minister of Energy. If it is an aircraft, there is need to obtain consent from the Civil Aviation Authority. Because when you think about it, creation of a security interest on paper is quite easy. The law has developed to such a level whereby you can register anything on SIMPA as long as it is not immovable property. But it is easy to sit back and think you have created a valid security when in actual sense you have, for lack of a better word, you have air. So that's why it's important to look at the applicable laws to know, one, which documents will be required, which consents will be necessary, and things like that. So the other issue is the signing modalities, yeah? And this is also important for the same reason that I mentioned above. Certain laws require certain signing modalities. For instance, mortgages require, the RTA requires that mortgages are attested to by one witness. The qualifications are various: lawyers, medical doctors, and things like that. So when certain signing modalities are missed out, then it affects the validity of the security interests that are created, and the validity of the security documents themselves. That's the second consideration. Third, the commercial arrangements between the parties. In my view, the banking and finance, the sector we are in, it has developed for so long that there are templates for everything. So it is both a good thing and a bad thing. It is easy to just get a document and change the parties' names without actually considering the peculiar things that are there in commercial agreements and things like that. Between the parties. So that's why it's important that you get specific details that are only peculiar to your transaction and consider it when drafting these security documents. And this also applies to the risks, which is the next point. As lawyers, we have the capacity to mitigate risks even before they happen, to sort of oversee the worst case scenario. So that's also important. The last three things to consider when drafting those documents: the tenor of the loan obligation. This will most likely affect the perfection mechanism that will be chosen. For example, if the tenor of a facility is, let's say, 3 months, 2 months, it may not be, should I say, advisable? Okay, it may not be beneficial to then go through the perfection process at RTA, but it may be instead beneficial to have a deposit of a title. So it would sort of be an equitable mortgage, but it's a call that the lawyer has to make on their client. Also, the perfection method will affect the documents you're drafting and also the enforcement options. As much as we have these things under our laws, we've encountered lenders who are just not comfortable with taking certain enforcement options that are available in the law. And the beauty about it is that the law will remain the law. Even if the document doesn't have a certain enforcement option, it is always available to the parties in the event that they decide to take it on at a later stage. Yeah, so we also have sort of a consideration, which is the execution formalities that as advisors that we have to take into consideration. One is the dating. And this may be, somebody might be wondering, it's obvious these documents should be dated, but they should be dated consistently. I'll give you an example. We've seen various documents where a witness signs and dates before the actual parties actually sign and date the documents. So in the event that such a document is contested, how will you be able to prove that the witness witnessed the person signing when they dated their signature before the actual person signing? Then also, you see, when I was saying about the relevant consent, there's a decision, I forgot its name, whereby the court said that the bank had not satisfied its obligation to ensure that the mortgaged property was not matrimonial property. Reason being, the spousal consent and the statutory declaration were dated after the mortgage deed. So the spousal consent was in short given in, should I say, to cover up, and yet chances are high that they could have been executed around the same time. So that's also important, dating. The other issue is, especially with perfection modalities, how dating becomes important. Sorry. Yes, how dating becomes important. There are timelines to these things. So for example, if a document is required to be perfected within 42 days, then, and clients usually delay with these documents, and by the time they bring them for perfection, the 42 days have since lapsed. So it's important that there is clear communication between the parties on the timelines between dating and perfection of the securities. The other issue is signing. by parties. And I mean, there are several cases, General Parts versus NParts, Frederick Zawe versus Orient Bank, that say signatures should be in Latin character. But you find situations whereby even the obvious, people just scribble signatures. So as a lawyer, you should be critical when you receive those documents to check if they have been executed properly. And most importantly for companies, you have to make sure that the people that purport to sign on behalf of the company actually have the authority of the company, preferably directors. Recently we were registering securities and we realized they had been signed by shareholders, and it was just always a mess when it's like that. The other issue is sealing by companies. Yes, so currently the law is open. Yes, if under the Companies Act, if two directors sign a document, then there is no requirement for them to affix a company seal, or it's not mandatory, that there is no requirement. However, where a company decides to execute documents using a company seal, it's always important that such execution is done in accordance with the members of the company. And this usually requires that maybe two directors or a director and a secretary sign these documents. And yes, where it's executed under seal. Then you also have to distinguish between a seal and a stamp, though it may not be very relevant these days, but there is a case. It's Nectar Uganda Limited versus Crane Bank, where the judge said that a mortgage deed was stamped instead of seal, and when he was trying to describe the distinction between a company seal and stamp, of course he used the fact that you should be able to, it's an embossment, so you should be able to literally feel the seal, which, and I have my own views on that, but yeah, so as lawyers we should take note of that. The other issue is witnessing. They should be properly witnessed, preferably as a lawyer advising your client, especially if they're a financial institution. It's better if the borrower has an independent witness. That makes it easier. Then the number of copies is basically just required for perfection processes, depending on the method that has been chosen. Okay. The next, which is most likely maybe the most important, is perfection of security interests. I mean, it's regardless of whether you're acting, regardless of whether you're acting for a borrower or a lender, perfected security interests it's beneficial, and it's always important that we advise our clients to perfect those interests. Perfection is basically making sure that these documents are enforceable and that the security interest has priority. There, I was distracted by a comment. Priority against third parties such as unsecured creditors, liquidators, among others. So perfection is basically, in short, it's just notice to third parties that, hey, I actually have an interest in this property. How is it done? Regardless of whether it's over movable or removable property, this is done first by stamping. Currently, stamp duty is nil. Yesterday's discussants went into the history of why stamp duty is now nil for most security documents. I won't go into it, but briefly, it's to make borrowing cheap. Basically, that's the primary reason. And as much as it is nil, the Stamps Act requires that a stamp certificate and a barcode is embossed on that document. Now the challenge with that is, whereas you can go into the URS system and declare nil stamp duty, it may be difficult to get a barcode without paying for a copy. But then also our perfection processes still need copies. For example, land, you need a stamped copy. So that 15,000 is nominal, and that should be okay. Stamp duty, when it's supposed to be paid for documents executed in Uganda within 45 days, then for documents executed outside Uganda within 30 days from receipt of the document in Uganda. Then the most important is registration with relevant registries. And I know mainstream, we only think about lands, companies, security interest in movable property registry. We have all done these registrations, and we are familiar with them. But where there are peculiar securities, it's also important to go deeper and try to find out which other registrations are relevant. Yeah, like I said, perfecting a security interest, especially on movable property, is the easiest. But that would also mean it is easy to register void security interests. Security interests that cannot be enforced because certain steps that maybe were not envisaged were not met. So where there are peculiar assets that could have regulation, things like that, please just cross-check and register with those relevant registries. We also have, anyway, so we also have statutory timelines. I think I've already mentioned some of them, but for a company, which is I think the most relevant, I think it should, okay, yeah. For a company, which I think should be the most relevant, is 42 days from the date the security interest is created. That is for movable property. For immovable property, and in particular land, it is 42 days from the date the security is registered with the land registry. Then, of course, it is prudent as lawyers for us to do. It's not uncommon for us to perfect securities and have titles that show encumbrances when in the system the mortgage does not show. That means a certain crucial step at the land registry was missed. And why this is important, remember, perfection is basically notifying the world. So if somebody does a search, a third party does a search on your property and on a property that you have interest in, and it does not show that there is actually a mortgage on it, then that there is some risk there. So those post-perfection steps are important. Yeah. The other issue is on priority of these security interests. Now, by and large, this is determined by either statute or by contract or both. By contract, these are security sharing agreements, subordination agreements, where creditors allow or agree to line up in a certain manner in case of default or anything. Well, but the most important one is the statute anyway. For statute, the Mortgage Act and the SIMPA are clear. For mortgages, mortgages rank in the order, priority of mortgages rank in the order in which they are registered. That's under the RT and the Mortgage Act. SIMPA, same thing. SIMPA, a perfected security interest, has priority over an unperfected security interest. For unperfected security interests, the priority is the same throughout. These rank in the order in which they were created. Now we also have visibility period, which is basically it affects priority in a way because it's basically the period between creation of a security interest and its actual perfection. So between that period, as a secured creditor or as a lender, the security interest exists, but third parties do not know about it yet, because most times there is a gap. And this is where now we have a conflict in our laws. For example, under the Companies Act, a security priority is determined from the date of creation. Yeah. However, under the Mortgage Act and the SIMPA, security is determined from the date of registration. Now, the challenge with this is if there are two creditors that have competing interests in the same property. Because under the Companies Act, the priority is from date of creation, whereas under SIMPA and Mortgage Act, the priority is from the date of registration. the question and maybe what we should keep in mind, or as it's a gap anyway, what we should keep in mind is, in the event of, let's say, insolvency or in the event of default, the question then would be, which one would take priority? Would it be the Companies Act or the specific laws, especially in terms of priority and things like that? Then the challenges that we have faced in perfection of security interests, and the very first one is managing client expectations. Clients, you remember, the sector we're in, by the time clients come, they want things done as quick as possible. Borrowers are usually desperate. Creditors and lenders are looking to meet deadlines, and so it's easy to rush through this process without looking at some of the considerations that I've mentioned and things like that. So managing client expectations, you have to balance the need to serve them because they are your clients vis-a-vis the need to follow the correct procedure. The other one is delays at the relevant registries, which we've all faced, which may be beyond them. I guess it's just a structural issue at LANS and URSP. We really can't apportion blame much, but those delays sometimes cause the systems can be down. The land system is also another one, so it's a lot. The other challenge is the dual registration process where companies are involved. Some of these have sort of been, or maybe there is progress to kind of align the systems. For example, for motor vehicles, now instead of perfecting both at SIMPA and then writing to the commissioner, to the chief licensing officer of Ministry of Works, now you are actually able to register a caveat through SIMPA and just pay the caveat registration fees and things like that. However, there are some systems that still need integration. It would be much easier and much more aligned if most of these systems were aligned. If for example, data from Ministry of Lands could be shared, or data from URSB could be shared with Ministry of Lands and things like that. So these are ongoing challenges that we should be prepared to sort of encounter. Okay, so the other issue, which I believe is important for us to know, is enforcement of security interests, be it on movable or removable property. Enforcement, though, I think that the main thing is that enforcement should be done to avoid challenges. It should be done in accordance with the proper procedure, yeah? And I can't exhaust the enforcement mechanisms or the options available to the clients and what. But, in the list, there should be a demand notice, notice of default, and then the mortgagee can decide, this is for immovable property specifically, the mortgagee can decide to exercise any of the options under the Mortgage Act, either to take possession, sell, appoint a receiver, lease, and so on and so forth. So practically, before I go into that, enforcement of security interests in movable property. So for movable property, SIMPA also basically lists down, SIMPA basically makes options available to a secured creditor when it's time for enforcement. The first one is taking possession of the collateral, and SIMPA outlines what can be done with a court order and what cannot be done with a court order. So without a court order, it's either or anyway. If the grantor or the borrower consents in writing to the secured creditor taking possession, which will most likely not be unlikely, then the collateral can be taken without a court order, and then also where possession can be taken without breach of peace. And breach of peace is defined therein to mean where either entering the premises of the debtor without permission or being physically violent. So if, or intimidating, then you can go ahead without a court order. Yeah. Then where the collateral is a fixture, it can be removed from the property without court process, where the owner of the immovable property agrees. Then we also have then the procedure in case I've just chosen one, in case the secured creditor decides to sell such movable property. There are several cases. It should be by way of auction after the 10 working days notice is from the law, is from SIMPA. I think that sums up basically the key issues on security interests. Thank you for listening. I see some questions in the comments. Belinda, I don't know whether we should go through.
Thank you very much, Linda, for that very insightful presentation. I see we have a bit of engagement in our chats, and we are going to respond to all the questions that have been asked in the chats, together even with the comments. So I think, Linda, let us start with the first chat, the first question. Just a minute. Okay, so we have Paul K. Shari stating that the problem of having some documents signed by shareholders can be squarely laid at the door of URSB. There are many instances where you submit documents and URSB makes strange demands on who should be able to sign them. So I don't know if you have a comment on that, because I know most people encounter a lot of challenges with URSB officials, especially on who is supposed to execute different documentation. Sometimes you submit those documents for registration and they query them. They're saying, no, we need, 1 minute they're saying we want the directors to sign, another minute they're saying we want the shareholders to sign. And so there ends up being a lot of back and forth in respect to that particular registration process. So I don't know if you have a comment to that.
Yes, I do. I've actually personally experienced some of those challenges, but the starting point should always be the law. Yeah, the law actually has certain requirements for certain documents. I mean, who should sign? Remember, a company acts through its directors. Yeah, so shareholders ideally are not supposed. They are the owners of the company, but their decisions should be made through the board of directors. So the starting point would be the law, yeah? And the law usually says who should sign what. Where there is an issue on, I mean, if your document is queried and the law says it should be signed by the director as opposed to the shareholders, our approach has always been to restate the law basically to these registrars. I mean, this is all a learning process for all of us, so always restate the law. Then about security documents being signed by shareholders, it also depends on the company memats, yeah? If borrowing in a company is supposed to be approved by shareholders, according to the company memats, then those documents should be signed, if those documents can be signed by the shareholders. But I mean, if the memats require that borrowing is done after being approved by the board of directors, then it is actually regular for shareholders to then be signing such documents. Yeah.
Thank you very much, Linda. The other question also is from Samuel Mugabe, who says, can a corporate entity waive using a seal and instead adopt the use of ink, stamps, and formally write to the financial institution confirming that position?
Actually, even before you go to writing to the financial institution, under the Companies Act, any document that is signed by a director of the company or by two directors of the company is presumed to have been signed under seal. Yeah, so that is the theory basically. So you can, I know the practice may be different, and financial institutions usually insist on sealing documents, but legally, theoretically speaking, two directors can sign without the need for using a company seal. Yeah.
Okay, I hope that clarifies it for you. We also have another question from Mr. Senkumba Ahmed. He's asking, in security sharing agreements, what distinction lies between pari passu and pro rata?
Okay. So pari passu means that the creditors will have equal ranking. So at default, all of them will be at the same level. Whereas pro rata means that the ranking will be according to the contribution. So for example, if one creditor has 70% of the loan and the other one has 30%, then that means distribution upon default will be according to those percentages. That's the distinction between the two.
Okay, we also have another follow-up question from still Mr. Senkumba Ahmed, who states that kindly clarify about witnessing documents executed abroad from different common law countries and non-common law countries.
Okay, what I can say is that Ugandan law requires that when a document is executed abroad, then it should be notarized. Maybe the question is whether non-common law countries then would have a notary public. And my short answer to this is that any alternative in the non-common, because I'm not an expert on non-common law, the alternative of a notary public in the non-common law jurisdiction would be the one to witness such a document.
Okay. You've also been requested to clarify on how many demand notices must be sent after default in immovable properties.
Okay. I think it's section, I think it should be around 18 of the Mortgage Act. This is my interpretation. I think there are 3 notices. The first one is the demand notice. And if that notice is not honored within 30 days of the demand, then you're entitled to send a default notice. Then that default notice, if it is not honored within, I think the section says 42 days. If it's not honored within 42 days, then you're then entitled to recover. So the way that section should be interpreted, I just don't have it right here, but you look at subsection 1, 4, 2, and then 3. So basically there are about 3 notices, but then there are also notices under the individual enforcement mechanisms. For example, there's a notice before the property is sold. There's also a notice, that is if they decide to sell. There's also a notice before if they decide to lease or to appoint a receiver. There are different notice thresholds that are specific to the different enforcement mechanisms. But generally, there should be 3.
Okay, thank you, Linda. The other aspect then relates to enforcement of share pledges. And I think this is a question that I have had in my mind. We even discussed this prior to this, and I asked, what is actually practically, how can we ensure enforcement of shares and security? And the reason I state that is that when you look at more advanced sectors in the world, they actually do a lot of loan against shares. In Uganda, our local banks have not yet picked that up a lot, and there is certain fear when it comes to use of shares as pledges to grant loans. But the bigger question then that I have for you is, how practical is it to enforce shares? In those advanced countries, you will see, even when you look at the UK or other countries, some of those countries have the borrowers executing, let's say, even blank share transfer forms. That may not be possible in Uganda because we have the OBRS system. And as you're aware, when you are doing any transfer of shares or anything, you have to use the borrower's system. Is it practical to even have the borrower granting you access to their system? Is it even practical having the borrower having, initiating the process of maybe even having that transfer, etc.? So I want to pick your mind on what is the practicality of enforcing shares as security, or what you would term as share pledges in Uganda.
Thank you, Belinda. Well, for starters, even maybe before we go into enforcement, I feel like I've cheated exams because we were having just this discussion just before we started. But well, for starters, banks are always looking out for the most certain way to recover their money. Now, the question is whether currently, in the current legal framework, at least as it is now, the question is whether the share charge is the most certain way to secure proceeds given by banks? That question is one, it's a debate, we can have it, yeah. Well, for starters, anyway, just before enforcement, shares in Uganda, especially in private companies, first of all, their value is hard to determine. The valuation is pretty complicated. Secondly, and that is because they are volatile, yeah? The way companies are managed in Uganda, you can't compare it to a security like land, which you're sure its value will always appreciate. So the valuation also becomes a challenge. Then other things like preemption rights, though of course I know this can be you can specifically draft the share charge in such a way that the company waives all these rights and gives an undertaking. Now for enforcement, we usually draft these agreements with things like powers of attorney, which basically give the creditors, the secured creditor, a right to transfer the shares upon default, and we also usually request for an undertaking from the borrower that there will be no preemption rights, there will be no amendment and things like that. Though strictly speaking, and then this just before that, there is this misconception whereby, I don't know, maybe it's because that's before SIMPA came in, whereby share charges were registered in the company in which the shares are held. And yet the requirement to register a charge is for assets that are owned by a company. Now a company does not own shares, they are not an asset of the company. So if company B is a shareholder in company A, and company B can then and then company B decides to pledge its shares or to charge its shares to company C, to bank C. So that perfection process should be on company B's account and not company A, which is the company in which the shares are held. Now, enforcement, now that you've clarified that, ideally where the perfection falls, ideally would be SIMPA. So ideally, the enforcement mechanisms under SIMPA should be applicable to enforcement of share charges. Now, practically, like you said, before transferring shares, that is done through the OBRS account. The chances of a defaulting borrower to give you access to their OBRS account is it's almost, the chances are very minimal. But then also, the way the law is structured right now doesn't enable such a transfer to be done through blank transfer forms. Blank transfer forms are actually illegal. So then the lender then cannot, or maybe why most lenders in Uganda don't prefer it as opposed to abroad, is because of the ease of enforcement and the transferability of those shares. What can be done? One, just like you've hinted on, benchmarking from from countries that have successfully done it. But then also it could be because of their sophisticated nature of transacting and how their companies are structured, as opposed to private companies. For such as in Uganda, I think it can be done, especially for public companies that are trading their shares on the stock exchange. Amendments to the laws can be done like that. Yeah, so I'm seeing a comment, sorry, briefly, that share certificates are held. Yes, share certificates can be held, but a share certificate is just proof that you own the shares. It does not give transfer. So just like you're saying, I think it's interesting. It's something that maybe we should consider, but also how to make, because shares can actually be a good asset, especially for our borrower clients, for them to leverage those shares to get financing. So it is interesting. Yeah.
Thank you very much, Linda, because I know it's a discussion that we're even having, and we're trying to understand how that can actually be navigated in our market, especially in light of the fact that we are increasingly having international financials that come from these advanced markets that keep insisting on saying, probably I would want to have the shares being used as security. And yet we know the nuances or the dynamics that are in our market. But probably to take you back there, so I know that you have probably dealt with international lenders that have insisted on, I want the shares as security. Have you probably brought this up to their attention? What is usually their take when it comes to this? But also, seeing that this is increasingly becoming common, how can we better prepare ourselves, especially the lawyers in this particular sector? How can we prepare ourselves to deal with international financials that feel that they want to use shares as security for particular transactions?
Okay. Well, one, as lawyers and practitioners, we are also risk advisors to an extent. Of course, we may not advise on all the risks, but for those international clients, our role is to tell them the pros and the cons. Yeah, you are interested in having security over these shares. Yeah, but this is the thing in Uganda: perfection, very easy. Enforcement may be quite a bit challenging, but usually by the time the lenders come to us, also they have also done their own valuations and things like that. But basically tell them the pros and the cons, the feasibility of enforcement in Uganda, as opposed to maybe what they are used to. I don't know if
Okay. I think that becomes an ongoing discussion, because it's something that is starting to pick up in the market, and knowing how to navigate that particular aspect would be good, especially for the clients that are coming from international spaces. But also, in addition, again, probably since I've taken you to that direction of practicality of enforcement of certain securities, again, I know we're having this discussion, but I think it would be a good discussion even for our online community, is on the contract of proceeds. We have seen numerous banks execute contract for proceeds with different borrowers, and every day we are perfecting. We are registering these documents. We are perfecting them, even registering them on Symposium. Now, my question is, what is the practicality of enforcement of contracts of proceeds? Well, knowing also that these particular borrowers have different accounts. I know usually most banks will state that, the borrower has an account with us, the bank, and when the money probably gets into this bank account, then we can be able to hold it at that stage. The question, though, is that we have borrowers having numerous bank accounts with numerous banks. Similar contracts of proceeds are being entered into. Assignment of contract of proceeds are being entered into between the banks and these particular borrowers. So what is the practicality of actually enforcing this assignment of contract proceeds? Is it even good security in the first place? I would like to pick your mind on that.
Okay, I'll start. In my view, I think it is good security. And for some of the things that you have just mentioned. Well, I think it also goes back to how sound your document is, yeah? I mean, the SIMPA regulations provide that where there's a charge in accounts receivable, in accounts receivable, the other party, the third party should at least be notified. So one, does your document have a provision for the third party to be notified? Two, if possible and where possible, have an acknowledgement from the third party. Of course, I understand the practicalities, the practical challenges. I'll give you an example. If a financial institution is lending money to a circle for on lending to, let's say, thousands of other Ugandans, and that the security is the receivables from those from that on lending, then it may not be practically feasible to give notice. And for 1,000 on people that you've on lent, let's say 1,000 circle members or border riders to acknowledge. But where it is possible, where it is practically possible, then such notices that increases the ease of enforcement at the time when you want to attach those accounts. The other one is making sure that the secured creditor has, like you said, has an overview or oversight over some of these proceeds. Though it is challenging because it may be interpreted as, a lender is not supposed to be so involved into the company, into the business of the company. But having an oversight, like creating obligations where they channel 100% of receivables through the bank's account. Now, your question on what happens when company A has charged those receivables to like 4 other lenders, and maybe they are channeling those receivables through other whatever. So all those are risks that banks or lenders should determine. Of course, it is not ideal, and I believe there would be provisions in those security documents that prohibit charging the same receivables to different creditors and all. So yeah, I don't know whether that clears.
Okay, thank you. I think again that always becomes an ongoing discussion, but maybe the last question for this particular segment, we have Edwin Buluma asking, is it feasible for regulators to come up with guidelines for charging and enforcement of security over licenses of a borrower?
Okay. My take on that is that I don't think a regulator would then have one should I say set of law or regulation, and this is why we can't exhaust the licenses. I mean, the electricity sector has electricity generation licenses, distribution. Mining and minerals has their own licenses. There could be other licenses that maybe I'm not even privy to that information. So what can be done, though? For example, I've dealt with some on mining and minerals. The law has, I don't even know that call them hints. They are just hints where it can hint that such a charge over any license should be registered or should have consent of the minister and so on and so forth. So I think what can be done, and something just came to my mind, like now, for example, aviation, there are some international regulations which were ratified in Uganda that create a register of charges. So it would not, in my view, it would not be one set of regulation, but maybe, like you said, like different regulators having different, should I say, oversight or picking interest in regulating the charging of certain licenses that they give out, and also not being, because it's growing in Uganda. I see it emerging a lot. So I think it's necessary, but it wouldn't be one comprehensive law. It has to be sector driven.
Okay, I wanted that to actually be the last question, but I see we are having a bit of questions in this particular segment. Maybe we can just take time time-wise, probably we can just take two last ones, which I see there, and then we close this particular segment. We have Kaomama Had asking, from your experience, which interventions can prevent mortgage disputes from escalating to court?
The first one and the main one, in my view, following the proper procedure. In short, that's it. Just follow the proper procedure. Of course, disputes will always be disputes. But you lessen your chances if your document is uptight, if there is no ambiguity, if the procedure is followed. Oh, sorry. Yeah. So proper procedure, basically.
Thank you, Linda. I think that is really critical, the fact that you have to, and I think Linda has really delved into these aspects from the beginning of her presentation, following procedures. How do we execute those documents? How do we do the perfections, etc., so that even when it comes to the point of enforcement, then we don't have aspects, mortgage disputes, escalating to court. It goes down to paperwork, how you have perfected, etc. We also have the last question, really, from Joanita, who is asking, how would a charge over a license be enforced in that case? Is it even practical? Would the creditor take over the business?
Thank you for that question. And that is why, for most regulators, just like I said, they hint on having the consent. For example, practically, it's actually pretty, strictly speaking, it is difficult, because if a bank has lent to a mining company and the security is a license, and there are certain requirements that a company must fulfill before they get a license. So you may hold on to a license that you have literally no one else to pass it on to. The capital requirements, technological requirements that are just beyond your control. So as a lender, I think it's also important to spread out the risk a bit. If you have a license, because these licenses are actually, and why they're usually taken is because they are literally the lifeline of some of these businesses. Some of these businesses, especially, and usually they are foreign businesses operating in Uganda that charge these licenses. Without them, they can't operate. So it's more about the leverage, in my view, the inducement or the motivation for those companies to pay, and less about the bank being so interested in a mining and minerals license. So it will most likely have other securities.
Thank you very much, Linda. It has been a very good session, great engagement, great presentation, and I believe we have learned quite a lot from your presentation. Thank you very much.
Thank you, Belinda, for hosting. Thank you, participants, for the questions. I would like to just pass a final thanks to the Uganda Law Society. Thank you for hosting me. On behalf of SM and co-advocates, we appreciate it. Thank you.
Thank you, Linda. That was a great deliberation and session that we have just gotten done with. We will now move to another great discussion. As I said, we have quite a lot we have in stock for you, and we are just getting started. We have bigger discussions, bigger deliberations, and I really implore you to stay on until the end of today's session. So our next session is going to be on data protection in the banking and finance sector in Uganda. Again, we are continuing our talk on AI and digitization of the banking and finance sector. Our speaker for this particular session shall be Mr. Silva Kayondo. Now, Mr. Silva Kayondo is a Ugandan and a South African dual trained lawyer and commercial strategist. with broad experience in technology law, emerging payment systems, AI adoption and integration models, data protection, and the fourth industrial revolution and value creation in the new economy. Silva is a founding partner as well at Otis Advocates, one of the leading and largest law firms in Uganda. He has honed his cross-border and international expertise at the Dubai office of global law firm White & Case. He's passionate about innovative problem solving and new age approaches to client service. Definitely his education and qualifications as well are quite robust. He has, of course, a Bachelor of Laws degrees from Uganda Christian University, postgraduate diploma in legal practice from Law Development Center, and he has a Master's of Laws with distinction from University of Pretoria. He has also gotten advanced certificate in insolvency and restructuring from South Africa Restructuring and Insolvency Practitioners Association, and strategic issues in leadership in telecoms, broadcasting, and postal regulation. This is from the Public Utility Research Center, University of Florida. As you can see, it is quite a very, very heavy CV, and I know we will be learning quite a lot from him. So he is going to come and then give us the next presentation for this particular segment. Thank you.
Thank you for reading my obituary so well. now that that's out of the way, I think it's good to be here. Three foundational things I'll say. One, of course, is thank you to ULS. It's my first time in this building, so congratulations to the membership. I think it's good work. Two is I'll say that how we approach the financial services sector at Otis, we take a very broad view of the sector. We don't just focus on banks, but we also focus on non-bank financial institutions. So I'll talk a bit about data protection in relation to capital markets, to CRB. We also view betting and gaming as part of financial services. So it's really broad. Plus, of course, venture capital, private equity, all those fall under there. The third thing I'll say is I believe the practice has moved away from foundational issues. So you will not expect me to be defining for you who a data controller is or a data processor. I think the Act has been in place for a while now. It's well tested. I wouldn't be adding value to define data processing, data control. So I'm just going to share a bit of snippets around things we have done or seen in the market in the last 1 year. So I think we dive in straight. So we are witnessing creative destruction of financial services. So it's no longer about the big fish, it's about the fast fish. So he who is fastest into the market and has better adoption and distribution models definitely will succeed, as opposed to those who do not have that kind of competitive edge. So, of course, starting from home and where we are, we've seen the implosion of mobile money and fintech prepositions. So fintech is financial technologies. So I think that's driving a key focus. We've seen banks recalibrate some strategies. We've seen formerly traditional banks obtaining NPS or National Payment Systems licenses just to create some nimble and agile structures through which to operate. Things like FlexiPay, I think we have Wendy at Postbank. All those are new sort of things that are data-driven, because the bank is a very huge behemoth to carry if you want to compete, say, with Momo or Airtel Pay, which are much more structured and nimble. So the result now is that financial institutions are now data controllers, and according to my findings from the Personal Data Protection Office, actually, most of them now have licenses, so they're compliant to that extent, meaning they have data protection policies, information security policies, and things like that. But also, regulators now have made data protection compliance part of the licensing requirements. You cannot have a national payment system license without showing compliance with the Personal Data Protection Office. The same goes for UCC, the same goes for Gaming Board, the same goes across board, in the sense that PDPO has been busy tying up MOUs with all these regulators to see how their mandate is enforced. So I'll run us through a bit of legal, judicial, and regulatory developments that we have seen, and then I'll end with some anecdotes of how practitioners interested in participating in this practice area can probably align and position themselves. I'm tired of meeting colleagues asking me, are you really practicing law? Are you really the thing is that I think we have to come to the realization that there is no single way of practicing law. Each of us has a magic sauce, a secret formula, or whatever it is that will work. So with the legal developments, I've talked about the Data Protection and Privacy Act. Definitely this is augmented by the Computer Misuse Act, Electronic Transactions, Electronic Signatures Act. So that's fine. But we've also seen a lot of international efforts that are morphing into global standards. Here I'm talking of the EU General Data Protection Regulations, but also the new European Union AI Act. Because to the extent possible, these say if you collect or engage in AI activities impacting data of an EU citizen, then you become bound around that. It goes without saying that the Ugandan Data Protection and Privacy Act is also extraterritorial in nature, in the sense that if you have personal data of Ugandans in your systems, definitely then you have to have a compliance metric that gives the same or superior protection to Ugandan nationals. In terms of judicial developments, of course, we've seen lots of disputes in financial services. We've seen IDATICU centenary. This was around confidentiality and disclosure of KYC data that enabled fraud to happen. And there we have the court attributing liability on the customer. And of course, now that moved into the Abacus, Parental Drugs, and Stanbic, where this one sort of tilted the curve and gave some sort of contributory liability to the parties involved around negligent data disclosure. Of key interest to note there is the principle of who stood in a better position to prevent or avert the fraud, So this ruling underscores the evolving nature of banking and risk allocation, particularly in the digital era. We've seen that market-exciting Google LLC decision, which clarified the applicability of Uganda's Data Protection Act to global platforms processing Ugandan data subjects information. I think the fat lady is yet to sing on this. We are waiting to see how PDPO will get compliance through the remedial actions it ordered and stuff like that. We have this recent decision, I think this was decided last week, Bitungwa Johnson versus URA and Lacan Motors, High Court of Uganda at Kabale. This reaffirmed the principle that the Data Protection Act is applicable to public bodies and institutions as well. In this case, URA had action around TIN numbers. It's available newly. So your TIN is also part of your personal data, so to speak, because it identifies positively who you are as a human being, as a data subject. We've had Kateria Gahassan and Shamila Nakawi, I think, also decided last week, a simple miscellaneous application also reaffirmed that bank statements are still discoverable in evidence despite data protection and privacy concerns. So if you're doing a case that requires electronic discovery, electronic inspections, and all that, and this will be key to note, particularly around the season we are going into of election petitions, because we are going to have a lot of electronic data transmissions and stuff like that. So electronic discovery and electronic inspections probably will be much more physical than physical inspections of documents, because you cannot ask Electoral Commission to give you this whole data room of presidential election results from all the polling stations in the country and expect to go through it. So those tools will be available in the market. Nalwega Margaret, Equity Bank, this was a defamation action that failed. It was premised on wrongful or incorrect personal data from the Credit Reference Bureau. In Kenya, these actions have succeeded as defamation actions, but in Uganda, court was a bit hesitant. Of course, there were quite issues with the pleading in the case, but it was, if you look at comparative jurisprudence, actually, CRBs can be held in defamation for supplying banks or lenders now, because the CRB now is wider. Even non-bank lenders can access or supply data to it. So these are a few of the cases I picked offhand to illustrate the point that judicial interest in data protection is significantly growing, and definitely litigation risk is an ever-lacking risk within the corners of our business environment. I'll now go to some of the regulatory developments that we have seen. So the key to note here is NITAU is in the, PDPO actually is in the process of making guidelines to cover some gray areas in the current framework. So this will cover basic aspects. There has been an update on the PDPO data registration portal that has going on for some time. So we've noticed that with clients, so we usually update them, tell them, look, we'll be able to file your impact assessment reports and stuff like that as and when the portal becomes operational again. We've also seen overlapping mandates, lots of regulators taking activity in this. BOU through outsourcing guidelines. I mean, right now, outsourcing and third-party risk are an extension of data protection risk, vendor risk. Even us as law firms now, you cannot be contracted to provide any services if you do not show proof of registration with Personal Data Protection Office. So if you're operating within the licensed client arena, definitely that's there. UCC, CMA, URSB as well. And also we've seen some anonymization of court judgments in certain instances involving children, particularly in divorce, family proceedings, which I must admit is my least favorite area of law. So I don't intend to be practicing divorce or marital affairs very soon. I'm pro-marriage all the way. So, question there, which you can reflect, is it time for a unified specific industry standard? I don't know, it's out of the jury there. Because with each regulator coming up with a standard, that increases compliance cost. And as banking and financial lawyers, we know that eventually that cost of business is definitely passed on the final consumer. So we cannot keep crying how, cost of access, financial inclusion is so high in Uganda when we are actually complicit in, processes that drive all these overlapping institutions, each doing the same thing. So I'm a strong advocate of data portability. If I have it, just ask for me. If BOU is my primary super regulator, you cannot, as IRA, because I have a bank assurance product, be asking me to take me through the same process. Just ask, certified, I'll avail it. If you want, it's up to you to do your own due diligence. Write to BOU, confirm. Indeed, have you given this party or this person this and this license? And if they confirm, then on the basis of that confirmation, I'll have satisfied compliance requirements. In terms of other regulatory developments, we are seeing a lot of RegTech and SupTech. So RegTech, so tech guys have all these fancy acronyms that we like. In their room, you can really be, the sector operates on a lot of buzzwords, which sometimes find themselves in regulatory text. So RegTech is really regulatory technologies. You know right now, if you're filing, say, with the Financial Intelligence Authority, you're not going to be taking physical hard copy documents. The same applies for if you're doing any filing at PDP or now. It's online portal, URSB as well, right? So that's examples of regulatory technologies. So we are seeing faster adoption. Same with CAA. There was an earlier discussion here on perfection of securities. Definitely, if you're going to perfect a security on an aircraft, you are not going to carry your things and say, CAA, I'm here. You know what? You have that. SupTechs are the supervisory technologies. So we are also seeing a lot of supervisory-based technologies, particularly at URA. If they are monitoring your tax compliance and things like that, definitely you're going to be intermediating a lot with their portal, even for generating simple things like returns, filings, and stuff like that. So this, for me, I think has aided how we work as lawyers. It's also arguably taken some out of business, but it's also enhanced. I'm able to do a filing wherever I am, as long as I have access to that. I've talked really about this. UCC is also deploying a lot of supervisory tech, particularly around monitoring of deployment of data services, location of masks, and other public sector assets. Right now, all assets are geotagged, that just from office, you can see that we have a mast in Kavale. It's, say, Ubuntu Towers mask or whatever mast, and you're able to real-time visibility have that. In terms of AI, there is this concept of explainable AI. So right now, if you're developing a tool, Bank of Uganda, if it's an AI-based tool, Bank of Uganda will expect it to be explainable. What this means is that if different people within the same segment give it the same prompt, it must yield the same results. The input should give the same output to mitigate effects of bias, discrimination, and all that. But also you as a developer, you must be able to explain the process of how, let's use an example, topical, AI algorithmic credit scoring. What that means in plain English is if I want to give you a loan, basing on data from maybe your previous transactional information on mobile money, or Wewole loans or something, how I score credit you if I'm using AI, I must be able to say, look, this is the formula we've put in, this is how the algorithm back end works, and this is how it yields the results. So that concept of explainable AI will morph into a guideline or a standard that's able to give further market guidance. So I close with the boring, dry policy documental issues. I come to where the money is. What transactional concerns are we seeing here? We've had recent M&A activity. Standard Chartered ABSA, the transfer of that portfolio is not just the transfer of books, it's also a transfer of personal data. So the transactional document there to use is your transitional services agreement. You're showing how the disposing entity is transferring this data to the acquiring entity and what safeguards the acquiring entity has in place. But also remember, under the Anti-Money Laundering Act, as an accountable person, you have an obligation to retain this data for 10 years, just in case there are any investigations or inquiries. So that obligation for any financial sector player, whether you are a casino, whether you are a bank, whether you are a law firm advising, you have to know that that obligation is within you. So that's activity we've seen, and I'm sure there is some compliance happening. Since it's a live deal that's undergoing, I'll not jeopardize my colleagues who are handling, so I will leave that at that. We've also seen some M&A activity instigated by the regulator through takeovers. I mean, we've had Crane Bank, but the recent activity we've had, I think, was with EFC and the Mercantile Credit Bank. So your data obligations do not go away just because you've been taken over by a regulator. You must retain that data for 10 years, meaning as part of the process, you have to be looking at things like regulatory approvals for archiving of this data. Of course, the regulator will insist on real-time access to that data, because we've had scenarios here where some subsidiaries have been taken over, and then you find the data is housed in servers of the groups outside jurisdiction, which has caused a lot of challenges regarding, say, compensation of people here by the Deposit Protection Fund, because there is that 10 million maximum which you can climb as a sort of deposit insurance. So it goes without saying that even the Data Protection Fund is a data collector, processor, and controller within the ambits of the law. So all those periodic updates they are doing, whether live or whether through nearer access, they have that obligation. So it's important that whenever you're releasing this information, at least you have some sort of data transfer agreement or data sharing agreement in place to govern the risk allocation in event of a data breach. So that is what we are seeing on the regulatory side within M&A activity. And of course, the documentation as process as well, data protect, but also warranties and indemnities in event for prior breaches, of course, that happened before M&A, those remain liable with the transferring entity. But for any post M&A or for any post merger or any post acquisition activity, that data breach obligation will be borne by the acquiring entity, because the breach happened when the transaction had already happened. So in terms of mitigation there, we are seeing some data protection insurance tools coming into the market. But in other markets, we are starting to see what's called representations and warranties insurance. So reps and warranties can be insured to make sure that any curve is covered, but also lots of anonymization and pseudonym use, particularly regarding transfer of data files. I think gone are the days now of the good old flash disk that helped us a lot in law school. So I think we are now in cloud, and it's important that cloud facilities as well comply with these obligations. As long, for now, there is vague activity around audit of cloud facilities, particularly in the sector. But I know that the National Payment Systems Act has required all NPS operators to have in-country data centers. This is meant to cater for those data sovereignty concerns. But of course, you can negotiate. If you're riding off group data, you can negotiate with the regulator to have at least mirror data centers so that they have still real-time access to that information they need for regulatory activities. I've talked of now the post-transaction integration. That's where I will stop with this ABSA and all ongoing transactions in the market. But also in insurance, we've had that Senlam and Allianz deal. So I think that also had specific consideration in the sense that if you're listed, definitely you're showing compliance not just with PDPO, but also IRA, if you have bank assurance or you're an insurance player, but also Capital Markets Authority, if you're, and USE, obviously, if you're listed. So the concerns for data protection around publicly listed companies also is much more stringent and intrusive, because here we are talking of a deeper and wider public interest than just ordinary companies. So I hope that satisfies that requirement. I really won't talk much about this comparative international experience. A few law firms in the market are doing this, so it's okay, I will leave that out. The recommendations, definitely, we anticipate some further regulatory guidance around how to treat M&A deal activity, particularly from PDPO in the regulations, or the guidelines rather, that are coming up. Now, I will shift gear to data protection and competition law. We obviously have this recent Competition Act. The market is excited about it, and so are we. I mean, we hope it creates work. But now, data is one of the leading competition drivers. No wonder that the initial dispute we had even before the act between Easy Money and MTN was about access of agents and agency networks. So he who has more data access in terms of consumer behavior, in terms of market positioning, is at a better competitive edge than a competitor who doesn't have it. But there is a big conundrum happening in the sector, in the sense that only about 5 million Ugandans have bank accounts, but over 40 million Ugandans have mobile money wallets. The banks obviously want to access a bit of that data. But if I were an MNO, I'd say no, because I've also incurred an acquisition cost all the way down to Kalangala, wherever, to access and have that profiling of the information. So we await to see, because what happens if I am a bank in retail, I don't have a specific client account, but an MNO has that information on their wallet, and the two want to intermediate. Where do I get the KYC? Where do I get all this other information that's needed? So that is going to be a very big fight. We are looking forward to it. I think it will be very good. The law firm that has its first hands on that, I think, will literally swim in money, because it's going to be an ever-ending problem that goes away. Then we have also another competition concerns. As we all know, the agent banking platform started out as a shared platform. And strategically, it was good at the time, because not each and every financial institution could manage or afford to develop its own agent banking product. But now it's morphed into a level where other financial institutions have created their own in-house agent banking platforms, but we also have one from the agent banking company, which is collectively owned by the Uganda Bankers Association. So how do you treat the two regarding if you want some data that's in one arm of the platform that you do not have? So all those are going to be very interesting issues to resolve. And of course, it goes without saying that we also have service providers like Google, Microsoft, Oracle, who are providing cloud banking services in the market. What happens if you wake up one day and maybe they are merging or being acquired? Do local institutions have that bargaining power and clout, to take care of these concerns and stuff like that? So a lot of topical things are happening, and we look forward to further developments. I've talked about competition law. I now want to switch gear to data protection, and I want to switch gear and talk data protection and insolvency. Your data protection's obligations do not go away just because you're in administration, liquidation, or receivership. How are we preparing our insolvency practitioners to continue with the reporting obligations from a data protection perspective in the event of insolvency? But also, what's the obligation of insolvent firms? We've had betting companies leaving the market, and the betting and gaming regulator has put the foot down and said, look, you do not do any data erasure until you've satisfied all the claims you have in terms of people's winning stakes and things like that, because that information is proprietary and internal to you. So if any person still has a subsisting claim against a betting company that has folded and left the market, definitely they have a substantive and valid claim through the regulator. And all this is going to continue happening because our market is one of the most active, particularly regarding telco sector M&A. We've had lots of, you remember Celtel, Worried, Zain, we've walked through the path, Orange, all that happening into the market. The key risks, of course, are there. You have lots of technological risk and challenges, even regarding legacy systems. The legacy systems, because it's fluid, to match new demand, to match new environments, they are always doing data upgrades and a lot of data repurposing. So what happens to the legacy systems of the old data that you had? What happened to the old files law firms had when, let me not alert law counsel, might be opening a can of worms to our business. So the last, as we move closer, I think I would love also to add a strand on data protection and corporate governance. Because now data protection is no longer just a staff issue. It's escalated to board level, that the board must be able to give adequate resources to the organizations in terms of human skill, but also in terms of financial data and financial capability for the staff management to be able to do their work. What that means is we are seeing lots of demand in increased routine training activities to board and management in this area. So with the quarterly board meetings, and I think, without bragging, I think our Emily Gakiza is one of the most adept practitioners in this area because of her over 15 years experience working with a top bank and seeing how activity morphs from, actual data management to actual stakeholder concerns because of the reputational risk, but also because of the prevalent frauds in the market now. At the heart of every fraud, particularly in retail, has been a data breach. How does someone access customer data? Either sometimes with the access of insiders or sometimes with active and willful participation of the customers themselves, because many of these are self-service channels, and definitely the obligation is there. Data protection and employment, lots of disputes we've seen. Many of these we've settled out of court. The strangest of those are how we treat personal data of applicants who've not succeeded in getting the job. You do not just throw people's CVs in the shredder and think you've done a good job, and then they're finding them at the Rolex and Mandazi places. Yeah, it's a strange place. I've ever found someone's HIV results wrapped in a Mandazi thing, It's so, definitely you'll be sued to bankruptcy if you're not careful with how you treat personal. They're already aggrieved that they've not got the job. Yeah. And here you are just throwing around their personal information to things. But also cases around departing employees, whether contagious or non-contagious. You've collected their biometrics, fingerprints, iris, everything, kidneys and livers, you have it all. And here you are severing obligations and you've not even cared to tell someone what you're going to do with their personal information. Of course, as a law firm, if you're in that context, you know you are an accountable person under the FIA. So just tell someone, look, we'll have this data for 10 years because the law allows us to do that. And then maybe after 10 years, it will either maybe be deleted or wiped or erased in that kind of thing. If there is anything you'd like to correct in the meantime, you still have a right to correct your data under the Data Protection and Privacy Act. Pay special attention to what the law has described as sensitive data, particularly health data. I've seen some financial institutions, particularly for senior management or for senior employees, collecting personal data because they have to take for you all these nice health insurance plans and benefits and things like that. So even something might start out as consensual and eventually even turn out into a data dispute that you didn't have access to. Cross-border aspects, we've talked of this, Section 68 of the NPS around data sovereignty, and different countries with different data protection regimes. So the law is clear, I think, that he who gives a equal superior standard will have that. Of course, most times we've had to get adequacy decisions. What we are seeing is intriguing in the sense that we know that, particularly in the financial services sector, that Uganda is largely a multinational economy, and many of our entities here are actually subsidiaries. So many groups are actually doing a data consolidation strategy. You know, they prefer their data to be housed at group, either in Nairobi or in Joburg or in Dubai or in the UAE. But this is starting to pose challenges, especially in the sense that he who controls the data also controls things like investigations and privity of contract. My contract is with your local subsidiary here. It's not with the parent. So in the event I want to correct my data, or in the event I suffer fraud, you are not going to give me the endless excuse that group is investigating, because they are not parties to the, I understand that's how you internally you treat your data. You want much more group control and things like that. But we've really noticed very concerning situations regarding investigations, particularly in fraud disputes. It appears that the access levels given to team members in subsidiaries is very little, that in the event, say, a card fraud dispute happens, then you're sending me to Visa or to MasterCard to process a chargeback and things like that. Yet I'm not privy to that relationship between you and the card network. You know, so I think there is need for much more scrutiny around this and how we structure our group level and subsidiary relationships. As I move closer to the end, of course, what emerging trends are we seeing? We are seeing a move away from fintech to tech fins. So the tech fins, fintechs are financial technology companies. These started out really as financial tech companies. Tech fins are technology companies coming into financial services. You've seen Google Pay. Even for a simple fitness app like Fitbit, I've seen they have Fitbit Pay, right? Can pay that. And of course, Amazon Pay as well. Soon you might have, a whole new ecosystem around that. So that influences also our business strategy regarding the kind of service offerings we provide these clients with. We've also seen a move towards super apps. Super apps really are the apps of everything. So you have a guy like Safe Border who started out as really a ride-hailing company now into Safe Car, doing liquor deliveries, they are the app of everything and are building toward that. And they have a payment systems license as Guinness or whatever, you know. So that we are starting to see as another market trend leading to data intermediation. It shouldn't shock you now if a bank becomes a mortgage company in Uganda. They have the information, they have the lender, they have the access to the KYC data, they have the payment platform. So the biggest competitor to law firms may not be law firms, it might be a bank. In the next few years, you just create a small spin-off companies focusing on securitization. And you get a license for that, and you're able to plug in and play directly without the middleman called a lawyer. That's what land digitization is going to do to law firms. When I started work, we were charging 5 million shillings for a search. Yeah, 5 million, because I mean, all these MSOs weren't there. I started my career at a top firm, so we're charging that. Yeah. We're also seeing open banking in the sense that banks themselves are starting to do interbank collaborations. I've just seen a tie-up, I think, between Postbank and, is it Stanbic or ABSA? I've seen that. I've also seen a tie-up between HFB and other banks, which I think are really good collaboration drivers. But at the heart of this is data exchange and information exchange, and it's important to make sure we're doing the right thing and advising right. And of course, regulatory sandboxes. CMA has launched the latest. IRA has one. BOU definitely, yeah. To be a little bit controversial, I also think that story is getting boring. I think we need one mega sandbox, because right now you will not build a tool just focusing on one product. Most likely, the product will be integrated. It's an app, maybe that's doing a payment system, it's doing a credit scoring, it's doing all that. And I cannot keep running to one regulatory agency at the time to get all this, you know. But I also think the time is right for an East Africa regulatory sandbox between Bank of Uganda, Bank of Tanzania, Central Bank of Kenya, and Rwanda. One of the reasons why our startups are filing is because of single market risk. Our market is too small to just build focused on one market. So we need to make it easy for people to scale in multiple markets at scale. It's also good for us lawyers, because rather than just advising on like a small Kampala thing, then I also get instructions to brief firms in other jurisdictions to also do markets, and then I'm able to charge a management fee or a coordination fee for that type of mandate. You know, I think for me, in terms of market development and market strategy, that's where we need to be looking. I've talked about cloud data, fraud, CRBs, outsourcing. I don't need to add more to that. I know it's online and trainings usually, the bandwidth is running low. I want to talk about this most importantly. Data protection, social media, and reputation management. Our banks are bleeding. I mean, this whole rise of X campaigns and whistleblower culture and activism most times ignores the real effect that goes to brand and reputation management of our financial institutions. True, we must have proper consumer redress and complaint handling mechanisms, but I also think it's very responsible to go onto the till and you're recording a video with your interaction with a teller over 50,000 shillings that you want to withdraw, and then you make a whole mountain out of a simple, anthill. And then, so we've had all these statements, statement on video, on management of our customers' accounts, centenary. We've had this fraud incident from Stanbic. I think Equity is one of those. We call them our long-suffering friends at Equity. I think it's been really bad to see some of this kind of activity morphing into, with actually some clients participating in their own data violations. You're busy posting your, financial statements and things like that online, and you know, just because you've had a consumer query that's not gone on unresolved. So that, of course, reputation management is key in the sense that now your brand is your value. Geopolitics of AI, China versus US, very good. I think on the consumer side, Uganda is largely locked in with the US. All of us are using ChatGPT, OpenAI. I have seen very little DeepSeek usage and adoption and uptake. Our financial institutions are taking a lot of Oracle Cloud, Microsoft Cloud, whenever we are doing advisories for core banking systems. We see Finacle, a lot of Finacle usage. So the Chinese involvement seems largely in the public sector. CCTV cameras, of course, how this interrelates with banking is, you know, part of this infrastructure is through loan activity. A public sector loan is taken for, you know, setting up of surveillance and national security assets and stuff like that. So important to note, as some of these players will also need Ugandan counsel. Where I lie, I am pro-US. I'm not going to start learning new cultures, new languages. I'm too old for that. But I encourage my kids to also pay attention to, you know, China developments and see how they can benefit to them. Existing gaps and challenges we see, lack of standardization. If Data Protection Office tells you to generate a data impact privacy assessment, everyone in the market seems to have their own template. I think we need to standardize because the risk profile of each sector is different. If you're advising a client like Pornhub, the risk profile is going to be very different from if you're advising a client like OpenAI. And trust me, those guys are always consulting because they have to develop global compliance toolkits and they will need some specific local law advice. So Ugandan, I know many Ugandan lawyers take offense when we say we are advising on local law issues, but I mean, it's okay. It's what it is. We also see overlapping mandates. I talked about that, UCC here, BOU there, URSB, you know. Data sovereignty, talked enforcement loopholes. I mean, PDPO is largely in Kampala. Violations happen on a daily everywhere. So I don't know how you can effectively police that, but we hope that some of these emerging tools can also pay attention to that. The cost of compliance, especially for SMEs, as I earlier hinted, that cost is slapped on the consumer, so making our costs and things go high. And of course, the limited specialized knowledge in the field. We hope that trainings and awareness sessions like this are able to broaden activities for this. In terms of risk management strategies that can be adopted, we've talked of disclosures, indemnities, waivers, disclaimers. Yeah, you definitely, even ChatGPT tells you, look, I'm not a lawyer on this issue, look for specialist legal advice, right? So definitely you always want, if you use AI to generate a client report, it's only fair that you disclose maybe some portions of this report have been generated using AI. And of course, if you're in litigation, we've seen lots of AI hallucinations and penalties against lawyers in South Africa, in Kenya. We've also seen an embarrassing situation where judicial officers are citing non-existent law and things like that in judgments. So definitely you want to be paying close attention to that. I think maybe ULS will have to come up with some bit of advisory note for us, because like guys like me are very endangered. Sometimes we even use AI without even realizing, you know. The thing is so in your DNA that, you know, yeah. So in terms of risk rating for AI, my anticipation is that the Ugandan standard will mostly mirror what's in the EU. So we have prohibited or unaccepted use cases. These are things like mass surveillance, manipulation of behavior in mass, social scoring and things like that. Those are a no-go area. We have the high-risk areas around conformity assessments, employment. We talked of health, law enforcement. Those are high risk because they deal with individual liberty, individual freedom, and personal autonomy. We have the limited risk ones here. We are talking of things like emotion recognition patterns, sentiment analysis. How do my clients feel about a certain banking product I've rolled out to the market? Things like chatbots. Lots of banks are using a lot of chatbots. Even me, I know right now people are Googling or asking ChatGPT, how do we really feel about Silva Kayondo's presentation? You know, so that's the kind of thing that's going. And then we obviously have the minimal risk. This is the low tier. And much of the adoption will start with the minimal risk use cases because the penalties can really be stiff. It's a total turnover of your global or national GDP, rather in annual revenue, gross annual revenue, if you're caught in a violation activity. So we are seeing a lot of wait and see, but also cautious optimism in terms of adoption. That is really the AI maturity curve. I don't know where Uganda or where we are, but even our individual institutions, some are in active stage, others in operational, others. I'm not aware of any institution that's at full maturity yet. All of us are learning, but even law firms, all of us are at different AI levels. Some of us use ChatGPT and think we've just used AI when we've just very tiny facet. Some of us, one of my best friends now is Grok. I'm really addicted to chatting with Grok. I really like. He's not a human, so no noise making, no over ego. So when I'm bored, he just tells me what I want, and then we can discuss anything from Shakespearean sonnets to the 8 wonders of the world, to Greek mythologies and anthologies. And of course, it tells me about my teenage crush, Anna Kournikova, ranked by Forbes as the 25th most beautiful woman on planet Earth. Lastly, and very lastly, I'll talk about the AI hype cycle. As we deal with this work, hype is real. I don't want you to fall for hype. There is real work. There is also a lot of hype and posturing and you know. So this is how the curve will evolve as we close to 2025. This has been the year of generative AI. We've seen lots of implosion. Gemini, ChatGPT, Claude, Grok, all those. But we are going to move to other use cases as the year ends in terms of edge AI, narrow AI, that really these have very superhuman capabilities. Grok is learning Nyachitara, which I really like, that I'll be prompting it in any language of my choice, and it's able to tell me, you know, how my grandma would perceive maybe a certain issue, so that I'm not saying offensive things over Christmas. Yeah, you don't go to the village and ask for risotto, right? You're definitely not going to cut it, okay? Right. Other than that, thanks a lot for listening to me. I see Q&As and things like that. Let's talk, let's engage. Thank you.
Thank you very much, Silva, for that very robust and very good presentation. It's great hearing about your attachment to your artificial friend Grok. I can imagine how the conversations are. Okay, so we have a bit of engagement in the chat section emanating from your discussions. We have Isaac Mpanga, who is saying that banks should just acquire the MNOs, let their holding firms bid to acquire these MNOs. I don't know what I think
it will most likely be the other way around. When you look at profitability, say, of MTN versus Stanbic Bank, the figures speak for themselves.
Okay. He also asks, when do the 10 years start to reckon in the aging of data?
upon termination, so upon conclusion of your relationship, say if a customer has given you notification that, you know, I'm ceasing dealing with your bank, that should start as the end point. But we have situations and market here where people just ghost, someone even leave you with their account balances. So that statutory timeline, say when you hand over their assets to the unclaimed asset base at BOU, that should essentially start the marking of the relationship, because at that moment, the assets are no longer in your custody, they are with the regulator. So different industries, even within financial services, will have different termination events.
Okay, we also have Samuel Mugabe, who is saying that breach of data processing and using banks involves many staff at times. There are many in-house data requests from departments like legal to other departments, and a breach can happen at any interval, making the custodian of such data liable. What measures does Mr. Kayondo advise banks to implement for purposes of limiting in-house sensitive data sharing?
Wow, hard one. Yeah, Sam is my friend, and yeah, so I know he's, yeah. Typical in-house counsel question. I know in-house. I don't know if this is not billable, but it's okay. I think it's different interventions. One, if it's digital data, even physical data, regarding the access controls in place. Who accesses what? What's a person not in loans or recoveries or maybe in legal doing with clients' credit assessments, for instance? You know? So you at an individual, you have to do your own data mapping, because I know also in-house teams are structured differently. You'll find some things are in board, others are in legal, others are in credit, others. So do your own institutional mapping and risk assessment to see who accesses what, who goes where. At the level of managing personal risk, there should be at least the way you have two-factor authentication, that if I want to release data or whatever, the bank maybe will ask me for my NIN and maybe send me an OTP. I think even institutionally, there should be some sort of two-factor authentication. If you come to me in legal saying credit this needs this information, there should be a note from the head legal or a minute on that file saying indeed we need that type of information for purposes of this and this. Either the loan is in default, it's a BOU inquiry, and if it's a BOU inquiry, definitely it will not be an oral inquiry. Attach that kind of request from BOU or FIA or any other person as legal photocopy and remain with a copy of that specific request, because this creates your data trail and a data movement ladder that you're able to push for and go on. For me, I even take it deeper. Whenever I'm releasing my national ID to any institution, photocopy, I write across the face of the ID saying, released to ULS on this date, this date. I don't want to find my national ID supporting a cause I don't want to be affiliated with, for instance. But I'm also able to know if I find my data out there regarding the institution through which it came from. Therefore, I'm able to also take some recourse action. So off cuff, Sam, that's what I can think about. And I wish you well with your team. I know you're going to do amazing things.
Okay, thank you very much. We also have a comment from Kauma Mahad, who says, what's the greatest opportunity AI presents to lawyers in Uganda?
Crazy. I think ULS should probably do a market mapping on this. It's very hard to resolve, because you ask the greatest opportunity, you want that one sort of needle from the haystack. From my personal data that I've done, which might be biased because the core clientele of ours is the big tech and the banks and all this. For me, it's about embedding myself into the legal departments of big tech companies, to the extent that the legal team at OpenAI should be able to know there is this guy called Zilva Kind in Uganda who knows what he's talking about. the team at Microsoft or at Google should be able to know, because those are the clients who will pay the type of fees that I want, right? But depending on how it's structured, you might think your greatest opportunity might be in class action lawsuits, aggregating victims who've suffered data breaches and all this, signing with them contingency agreements, and then retaining 40% of whatever you recover. I don't know. That might be your greatest opportunity. Your greatest opportunity might be in leaving the law firm and going to develop an AI tool with Stanbic Bank that will strategize or streamline mortgage or securities perfection using that. The answer is not linear. It might also be living, practice, relocating to a crater lake in Fort Portal and chatting with ChatGPT. It might give you less money, but more fulfillment in having a virtual assistant and virtual friend to give you company whenever you're bored and lonely. So I think for me, really, the choice is yours. Thank you.
Thank you very much, Silva. I think we don't have any more questions in the chat, but maybe to just pick your mind on one of the things that have been, in my mind lately. Do you think we have maybe this does not touch a lot on AI or
What's
data?
What's been on my mind lately?
Yeah, it has been. So the question is, do you think we have enough regulation for mobile money platforms outside? Do you think that the act we have in place is robust enough? And I say that because we are now increasingly seeing that mobile money entities are controlling a lot of money for different customers. You indicated that majority of the people don't even have bank accounts. They hold their money with these mobile money entities.
Yeah.
Now, do you think because you see with banks, there is enough regulation. BOE is always having stricter guidelines for banks.
Yeah.
But do you think we have that for mobile money entities, especially since now they're even doing savings for people, they're issuing loans, they're now payment. So they're doing essentially a lot of, on the ground end, what essentially banks would be doing, but probably lesser regulation. I don't know what your comment on that would be.
Yeah, my view on that is a bit unpopular. When I was young and still intelligent, I had this very blind faith in regulation. Now that I'm old and senile, I really lost faith for regulation. I am for pro-deregulation. I actually think some of the things we have in our regulatory system are very sophisticated for this market and should be abolished. So, and if I'm to be a little bit selfish, as a lawyer, you don't make money when the rules are clear. Yeah. When the law is clear, where is the demand? So I actually think we don't need, we probably need few, maybe two, from a mobile money perspective. I think we should have some sort of deposit protection for mobile money, because the disputes, I think, it's no longer enough to rely on trust accounts and stuff like that. So I think that's needed because it's a pro-consumer thing that adds more trust and confidence in the ecosystem. But on the remaining thing, BOU, please, I request you leave us. Don't interrupt the party. Mobile money grew because it was unregulated. That's what spurred growth. Now that the mistake mobile money made is that it became the goose that lays so many golden eggs. Now in an attempt by Ministry of Finance, URA, to squeeze as many golden eggs as possible, they have killed the goose. You know? So all these mobile money taxes, all these kinds of things, I think are a bit too early for this ecosystem. Let it grow, you know? Once you let things grow, you encourage economic activity around it. You're able to sacrifice short-term gain for long-term gain, because the way the tech ecosystem works is it works on economies of scale, what we call network effects. The more the people, the more efficient the more efficient the system. Even if you're charging I think mobile money, if they really want to tax, should be like 0.1%. Then everyone is able to crowd in. The day even the guy on this, because if you go like to Nairobi now, even the guy of the motorcycle, Bajaj guy, will not accept cash. There is incentive for them to lipana M-Pesa, lipana M-Pesa, right? So now once you do that, then you know that then the other things will come. Because right now, as I was making this presentation, the tricky thing with tech is you might find 20% of it from the time I sat here up to now has already become obsolete. Yeah, things have already been overtaken by events as I was still. I'm even hesitant to release this presentation to the public. Yeah.
Thank you very much, Silva. I think you touched on something also that I was about to bring up, the aspect of protection of that particular money, because you see, the mobile money entities then have these trust accounts, but me as the consumer on ground, I have no visibility over those trust accounts with whichever banks that they're holding those the monies in. But then when we know the regulations from Deposit Protection Fund says, if anything were to happen, we will protect you to 10 million Ugandan shillings. What then happens with that money that is held in trust accounts? Who actually is going to bear that responsibility?
Yeah, no, so one is the trustees are the gatekeepers, but also under the National Payment Systems Act and the regulations, there are rules of dormancy, through which process your money will be taken up to the point it's sent back to BOU, and if you don't claim to BOU, it's sent to the consolidated fund. We had hoped that that money would actually go back to the sector to redevelop, infrastructure and things like that. But we lost that debate, and I'm bound by collective responsibility because I was one of those who were part of the stakeholder consultation for the NPS Act and regulations and all that. So I will not, but give it time. I've started seeing a case being made. South Africa has quite developed payment systems. Of course, mobile money not yet. I think Africa will leapfrog the cards. Cards will not be a big thing here as they were in Europe, sadly, or fortunately, I don't know. So I'm starting to see demand. In Kenya as well, I have seen a proposal by the Kenya Bankers Association around regulatory reforms. Yeah, to create some sort of deposit insurance for this. Maybe the last strand, 2 strands I'll add on that is that we all know that deposit protection arose largely out of the global financial crisis. It's one of those Basel requirements, and therefore, naturally, it was targeted to the banks because they were the largest culprits that plunged us into the crisis in 2009. But now with the kind of changing consumer dynamic is that increases the risk of contagion spread. That risk could even emanate from your non-bank sector and spill over into the formal financial institution. Hence, all these changes we are seeing, the registration of the large circles, all this because they control a substantial amount of deposits. So I think for people who are interested in policy work, in regulatory work, but also in writing, this is a potential area for you to go into. Yeah, you write. You do not know. My philosophy is you do not know or understand a thing well enough until you've written about it.
Okay, we have one last question on the chat from Collins to Mukonde, and he says, "Hi Silva, do banks have a remedy where social media is used to spoil the brand of the bank due to isolated cases of data breaches?"
Yeah, I think those remedies are there, and we've seen some of them in our jurisdiction. We've seen DFCU moving. Was it the case concerning the late Rajiv Ruparelia at DFCU? Isaac Mpanga might know this. I've seen that. I've also seen some cease and desist notices from banks to offending entities. I've also seen reports to BOU. Some Bankers Association has raised this issue with BOU. I don't know what BOU is doing. Maybe at future engagements, it will make sense to have the regulators in the room as well, so we can hear their responses to some of these things. But other than that, some things are beyond law. We are talking of PR strategy here. Sometimes you also don't want to be seen as a bank entering, a war with a customer for, kind of thing. So the PR strategy at the moment, acknowledge the issue, deal with it in-house. If you feel the public deserves to know, come back and tell, this was resolved, customer is now happy. If you're a very good strategist like me, also have the customer tweet saying, I confirm this is the position. Thank you.
Okay, thank you very much, Mr. Silva Kayondo. It has been a great discussion.
But I get paid in muffins and...
Yeah, but thank you very much, and we wish you happy chatting with Grok. Yes.
Thanks, members. I remain available. LinkedIn, Twitter, Facebook, wherever. To the extent that I can assist, I'd be glad. I'd also like to appreciate Patricia Katsabe, our associate at the firm, with whom I worked with on this presentation. I think it's good, and I really appreciate the support we have from the entire team at OTAS, and we continue upholding our same values of excellence, professionalism, and
okay,
yeah.
Thank you very much. All right, that was a very insightful session talking AI data protection in the banking and finance space, and I hope we have picked up a bit of the things that we wanted to learn. We now are going to move into our next segment. As I told you, we have quite a bit for you, very good lineup for you today. So our next panel discussion, this will not be a presentation, but rather a panel discussion. And the panel discussion will be on an overview of cross-border financing in Uganda. I know there was a question actually in the chat where they wanted to have an understanding on the different securities that international lenders are big on, and I think some of those aspects are going to be handled in this particular session. The person that shall, the moderator for the next session shall be Esther Nafula. Esther Nafula is a seasoned banking and finance lawyer with over 10 years of experience advising lenders, borrowers, and financial institutions on compliance obligations within Uganda's dynamic financial services regulatory regime. Now, she has extensive expertise in cross-border financing transactions, of course, including the drafting and negotiation of loan agreements, syndicated and bilateral, project finance, trade finance, and advising on corporate, on capital controls, central bank approvals, and reporting requirements. Esther holds a Bachelor of Laws degree from Uganda Christian University, Mukono, and a postgraduate diploma in legal practice from the Law Development Center. She also holds a degree in master's degree in corporate and commercial law from the University of London. She has participated in several specialized trainings on cross-border finance, including the Africa Legal Support Facility inaugural training, ILFA Banking and Finance training, Clifford Chance training in Nairobi, and DLA Piper training in London. She has previously served on ULS Female Lawyers Committee and currently sits on the Banking and Finance Committee of the East African Law Society. Yes, she has a very, very heavy CV. I hope I've tried to do justice to her bio. She will take us through the next session, which should commence in maximum about 5 minutes, really. Thank you very much, and stay tuned for the next panel discussion. Thank you. Okay, thank you very much, Uganda Law Society, for this opportunity and for our participants who've joined in for the discussion on an overview on cross-border financing. Okay, I'll repeat that for those who couldn't hear me. Thank you, Uganda Law Society, for this opportunity, and thank you for the participants who've joined in on the discussion on an overview of cross-border financing. So I'm going to introduce my panel, which is full of very seasoned lawyers. I'll start with Natasha. Natasha Ahimbisibwe is a senior associate in the Banking and Finance Department at SM and Company Advocates, formerly Shonubi Musoke and Company Advocates. Natasha has a master's in banking and finance from the University of London and also has a qualification of Poditra from the East Africa Tax School. Natasha specializes in banking and finance, law and practice, and her core practice covers cross-border and emerging markets, financing, asset-based financing, structured financing, agriculture financing, commodity financing, and project finance, among others. So you can see she's very seasoned. Natasha also advises a wide range of both international and local lenders and development finance institutions, as well as private equity firms. She has previously been a panelist and facilitator at the Loan Market Association Conference in 2023 and 2025, and the International Lawyers for Africa Academy, IFLR. She was the lead associate on the IFC, Standard Bank of South Africa Sustainability Financing to MCOPA, which deal received the Loans Deal of the Year award at the IFLR Africa Awards in 2024. Natasha is part of the team that reviews the Loan Market Association review and standardization of various documents for use in Kenya, Zambia, Nigeria, Tanzania, and Uganda, and the related user guide. And her practice in the banking and finance sector has earned her a nod from IFLR as a rising star in 2021, and also a notable practitioner in 2023 and 2024. So Natasha, we are honored to have you on the panel. As you can see, feel free to ask whatever questions you can. As you can see, her experience is extensive. Moving on to my next panelist. My next panelist is the only gentleman, and he's Emeron Gerald. He's an advocate with over a decade of experience in investment banking advisory, and he's a seasoned banker. He has worked in various banks in Uganda, including Absa Bank Uganda Limited. He's currently working with Stanbic Bank, a subsidiary of Standard Bank of South Africa. He supports the corporate and investment division of not just Stanbic, but also the regional corporate and investment divisions of its affiliates across the African region as the senior legal advisor, corporate and investment banking. He has advised on various transactions involving the sovereign, both global and multinational organizations, large and corporate, among others. You're welcome, Gerald. My next panelist is Birungi Kaburara Mugisha. Birungi is a partner in the corporate and financial advisory practice of Otis Advocates with over 14 years experience. She also serves as the firm's chief operating officer. She brings extensive cross-border expertise in corporate advisory across multiple industries with a focus on corporate reorganizations and transaction structuring, including business sale and purchase transactions. She adeptly manages due diligence processes, drafts, and negotiates key transaction documents, and she oversees mergers and acquisitions, including post-acquisition, integration, and advisory. Her experience extends to private equity and venture capital transactions, where she supports founders in launching and scaling emerging companies and advises investors on funding early and growth stage ventures.
Birungi also advises on a broad of financing transactions representing both borrowers and lenders, from local transactions to complex cross-border transactions. Her proficiency in financing complements her corporate and commercial practice, ensuring a cohesive, solutions-driven approach to clients' needs across sectors. She's also consistently ranked as a leading lawyer by several reputable lead rating agencies, including IFLR and Legal 500. Her qualifications are: she has an LLB from Makerere University, and then a postgraduate diploma from LDC, and an advanced certificate in foreign policy analysis from the Lincoln Institute of Diplomacy and International Relations, the University of Delaware. You're welcome, Birungi. We can't wait to hear what you have to share with us. Then my last panelist is Sheila. Sheila Ann Pakito is a partner at ENS, and she's a partner at ENS Uganda with a specific focus in banking and finance law. And her experience includes routinely advising clients on the terms of financing and negotiating these, as well as preparing and reviewing finance documents, registration and enforcement of securities under Ugandan law. Sheila has acted for a variety of local and international clients, including those in the finance, leisure and hospitality, education and logistics industries, particularly in transactions involving corporate and project finance elements. She's admitted as an advocate of the High Court of Uganda. She has an LLB from Makerere University and a postgraduate diploma in legal practice. She's recognized as a leading lawyer by Chambers Global, the Legal 500. She was recognized as a rising star, and then IFLR as a rising star. So welcome, a warm welcome to all our panelists. Now, as we delve into our discussion today, I know some of our members in the audience may be wondering what cross-border financing is. And in simple terms, it really refers to obtaining funds from across borders. For example, if you have a borrower in Uganda and you're getting money from the UK, that amounts to cross-border financing. And that type depends really on the needs of the borrower or the lender. So before I preempt our next discussion, I'll stop here and let Ms. Kaburara tell us. We hear complex words like syndicated, bilateral, sovereign. They all sound so complex. How would you demystify cross-border financing in the Ugandan context? And what are the most active product types you see today across corporate, project, real estate, and how are these deals typically structured? Over to you.
Thank you so much, Esther, for that kind introduction and remarks. So very simply, cross-border financing is really any financing arrangement or deal where the capital or the lender and say obligations cross our national borders. Now, where it becomes critical for our economy is whilst we have domestic banks in the country, they do have, they mainly rely on short-term deposits and also have balance sheet limitations. And yet most of these crucial maybe projects we are looking at in the sectors of infrastructure, we're looking at energy and even industrials are very capital intensive and are also long term. So that's when now you'll have the international lenders coming in to bridge this, fundamental mismatch. So one thing also I think we need to appreciate about, cross-border financing is really it's about de-risking. And when I say de-risking, it's just risk management, reallocating, reducing risks that would otherwise make, a project too expensive or simply impossible to finance. So that's when now the international lenders would, come in. So the ultimate goal of cross-border, financing is to make sure that the project is really bankable. So we're going to look at things like transforming this high-risk project into a financially sound project, legally robust, and also, internationally investable. So investable is really another word for bankable. An opportunity. So in there, we'll address things like commercial, political risks, and then structure a deal that meets that stringent criteria that international capital offers. If I may get into, say, the second part of your question, I think it was about products, right? So the products that we are seeing in the market are along, project financing in a nutshell, which is, long-term capital for specific assets. So that's energy plants, roads, industrials. And here the lender is really relying on future cash flows and not, the balance sheet. And they're backed, say, by, contracts and maybe power purchase, but I think we'll get into that later. The other product we see is syndicated loans, where you would have a borrower who needs a large, sum of money, and then they would have to bring on multiple lenders to be able to co-lend. So in there, you'd have local lenders together with, other, say, 2-3 international lenders, creating that syndicate. The other one we've seen is multilateral financing or development finance institution, which is really about financing development projects. So in here, we're going to find the likes of African Development Bank, we're going to find the likes of International Finance Corporation, we're going to find the likes of Africa Finance Corporation, among others, who offer loans at softer terms, longer repayment periods, to be able to meet those development projects that we're looking at. And typically they'll have sort of like ESG linked conditions and also technical assistance. The other type would be equity and mezzanine. And equity simply means, capital coming in from the private equity funds. We have mezzanine venture capital funds and also impact funds. So mezzanine is simply a hybrid, or it's a consemblance of equity and senior debt. And then we also have sovereign and quasi, sovereign borrowing, where we have either government or state-owned entities borrowing from the earlier parties that I've mentioned. Could be development finance institutions, multilateral, and even export credit agencies. So, and those would, typically be along the usual structures of, is it a term loan? Is it a revolving credit facility, which we shall then, break down later. Thank you.
Thank you, Kaburara. It's interesting to see how many different cross-border deals are going on in the country. I recently worked on a transaction where it was called factoring. So the way it was structured is that receivables are pledged to the financier. So the financier was situated in another jurisdiction, and the person manufactures buses. So they were also in another jurisdiction, but they wanted to bring on the buses to Uganda. So that's how the deal was structured, and it's interesting how we keep learning. So moving on to Kaburara, from a Ugandan lawyer's perspective, what are the top 3 risk issues you prioritize at the outset when it comes to a cross-border transaction involving a Ugandan borrower or Ugandan assets?
Thank you, Esther. In terms of top, well, there are quite a number of risks, but let me try and see how I can compress them into the top 3. So I would put them in sort of like buckets. And the three buckets are really regulatory, capacity, and authorization. That's the first risk I would, advise a Ugandan lawyer to really look out from. And the question here you're asking yourself is, can they even do this? So that's what the bucket is. So you're going to look at things like corporate authority. Here you're going to look at, conduct due diligence on maybe the constitutional documents. Do they have the valid board and shareholder resolutions? Are there any constitutional limits in terms of borrowing? Are there any thresholds? And if there are thresholds, how then are you going to, advise the client accordingly? The other thing I'd also look at is, in terms of can they even do this, is sector-specific, restrictions. So if we're advising, say, a client who's in the energy sector, you would have to definitely look at things like the license or the power purchase agreement, because in there there would definitely be a restriction. If you're advising a client who's lending in the telecom sector, are there restrictions coming in from the Uganda Communications Commission that then, create restrictions on creating security and maybe even securing prior consent, among others. And then also, we've recently advised on a public sector borrowing, and in there we had to address our mind to the directive that was given by the Ministry of Finance, I think back in 2016, that requires all public sector deals to be negotiated or dealt in Uganda shillings. However, there's an exemption when they're borrowing from development finance institutions for them that allows them to have the deal in foreign currency. And then I think the second bucket then would be regarding security perfection and structural cash flow. So in here we're asking ourselves, is the collateral solid and can they pay back? Okay, so if the collateral is solid, we're looking at things in terms of has the perfection been done properly to ensure that our lender has a first priority and enforceable security. We're looking at the timelines within which the security was registered, among others, lands registry, companies registry, even SIMPA. The other risk I would, advise on would be foreign exchange and cash flow. And the good thing is that Uganda is a very liberal economy, so we do not have any exchange controls. But the question then would be, is the borrower then able to pay back the money? So we're looking at things like the borrower is in Uganda and they're earning revenues in Uganda shillings. However, they've taken a loan in foreign currency. So then that's when you look at you look at scenarios on how to protect the lender's interests. So you're going to look at things like, do we have a debt service reserve account, which is basically an account where you keep a buffer in case the revenues take a dip, and then you're able to, tap into that debt service reserve account and service the account, service the loan, sorry. Or we're looking at the cash water flows. So the first thing, what we've seen is, paying taxes first, paying for operations and maintenance, and then you pay the lender, and then the last thing should be the shareholders in terms of dividends. So then that gives comfort to the lender that that my loan is going to be paid. I do not want to be an expert on this. I think since we have Gerald here with us, but I do know there are other mitigation mechanisms like hedging or multi-currency accounts where you're going to look at, I think they're called swaps, derivatives. So Gerald, if I may, Gerald, you could just maybe build on that. Yeah.
Thank you, Cabrera. So Gerald, over to you. Since you're usually the client that participates in these transactions as the lender, from your perspective, what risks have you encountered, and how are they usually mitigated? So that we build on to what Cabrera just said.
So I think there are very there was a word that Cabrera has touched on, and usually when you're sitting in a committee which is approving a particular transaction, there are words that then come out. And the first question that an approver will ask you is this transaction bankable, right? And these are the questions that then you have to answer both from a commercial perspective as well as from a legal perspective. So when you speak of risks such as forex, foreign exchange risk, market volatility, the default, those are some of the things that you then have to guide on. But from a practical perspective, I think when you on the outside, a deal has been presented and then the decision makers are in a room where you're not, there are certain things that they look at. When it comes to cross-border transactions, I think there can be a comparison with what you have in other jurisdictions. Whereas you see, Cabrera has talked about regulatory compliance. You find that Uganda is liberal, where that question won't arise. But then you go to jurisdictions such as Angola or Mozambique, they will ask you whether you've obtained central bank approval, right? Here the central bank is a bit liberal to the extent that you can then acquire financing from a player that is not in the market, or you can even use those funds outside the market from where you've acquired them from. But if I'm to speak to some of the risk mitigants, and the major ones, I think Cabrera has talked about them. The debt service reserve account, where you're saying that, look, in the event, first and foremost, let's start from here. Money is not disbursed based on security. Money is disbursed based on cash flows. But then you're looking at a situation where, in the event that the cash flows are not able to sustain it, what do you do? And that is more like a plan B. And if you talk to some of the big players, Standard Bank, you're talking to ABSA, you're talking to the Standard Chartered, even I would like to think even UDB, I think it's more of a long-term goal. When I'm financing, or when you're considering a financing for someone who is going to, for example, do an eco-friendly project, you're thinking of what is the effect that that project is going to have on the society, on the people who are there, right? So when you put in mitigants such as debt service reserve account, you're saying that, look, over and above the security I have, in the event that the obligations are not met in full, what do I need to cushion myself? Because the moment there was a default, or the moment that there was, let's take an example of a default. The moment there was a default, then you go into the realm of provisioning. And when you're entering into the realm of provisioning, you then have to be out of pocket. You all know that some of these players, both local and internationally, they are using funds that are customers' money. It's not ideally their money, right? So when you tell them to provision, you're telling them to go deeper into what they have already invested in you. So, and those are the risks that we are trying to do. Recently, we had a situation where we put in place a debt service reserve account, and it's a very good measure, but then you have to think, in the event that is not funded, then what happens? It's in place, but what happens? Because then we had to now create a sort of like a stopgap to say that the moment that amount of money is dipped into, the moment you touch it, it triggers them to fund the account. Because if they don't then fund the account, that's also an event of default, right? So you find that some of these lenders who deal with those syndicated transactions, they sort of try and put in place mechanisms to try and say, in the event that I do not get, in the event that the borrower does not meet the obligation, what do I do? It happens whether it's a commercial client or it's a sovereign. The principle is the same. At some point, the obligations have to be made. So when you look at issues of currency risk, obviously that one, you mitigate it using a hedging option, where you're telling the customer that, look, you're trying to say that in the event, it's more of a forward-looking mechanism. You're saying that it's possible that we are entering into an election, or there was going to be an election in the US. It's possible that the currency may either be stronger or weaker. So the question is, we're asking you, the banks are telling you, can you put in an option right now to make sure that in the event it goes stronger and you're in a deficit, you at least cushion. There was a rate at which you'll exchange those monies without necessarily being out of pocket. So when you find words being used like, swaps, derivatives, or hedging options, they are trying to tell you that, look, in the event that the currency is to either go deep or appreciate, what do you stand to lose as a person? Obviously, even the banks are saying that, look, I don't want to lose. The silver, more like the cutthroat position that I've seen being taken on the market, is to put in a condition, even in the facility letter, to say that in the event that the currency depreciates by a certain threshold, you then give me the powers to then convert your loan, right? Obviously, that is a bit dangerous, given that you have a number of local corporates who are literally just trying to branch out. So you do not want to stress them to the extent that they will not be, it then causes them to drop and even lose business, ultimately even exiting the market, right? So you have options, for example, if you're dealing with foreign exchange loans, you have the option of a hedging, interest rate swaps and derivatives to try and curb the volatility of the currency, depending on which currency you're dealing with. And it primarily depends even on the circumstances of the jurisdiction. I just wanted to touch on some of the benefits. I think from the banker's perspective, some of the benefits for cross-border financing, right? It has its disadvantages, but then some of the benefits is that you expand your horizon to the extent that you're increasing your capacity to borrow. You're given a much larger avenue with relatively friendly rates, because when you're dealing with some of these developmental banks, you would find when you compare their interest rates to commercial banks, it's relatively better. So if you then get an opportunity to then access financing from some of those developmental banks, the DFIs of this world, then you would know that some of those have a better edge as compared to a commercial bank. Then also that speaks to the affordability of some of those borrowing options. Then also you're looking at access to variety. You have access to either seek financing to do either general corporate purposes or to do a project finance or even just term debt, right? So you have all these options in one where you can equally be able to access. Then also helps borrowers also to tap into the international trade, because ideally ultimately that's the market that we are all garnering for. When you look at the crown beverages of this world, when they are able to export some of their products to some of our neighboring countries, you then know that some of these are possible because there was someone in that company who has a much bigger view than the local jurisdiction. And sometimes you find that you may not get that financing locally. Here locally, you're talking about single obligor limit, where there was a single obligor limit that every bank is allowed to go. But now when you go to entities or financial institutions across the border, they know how to maneuver that. That's why you'll find that you'll have deals like syndications, those ones where they'll invite other players, other lenders to come and participate in that transaction without necessarily breaching that. Then obviously some of the disadvantages that we have spoken of are the risks that we have spoken of. Political risk would be one of them, where recently an approver was put us aside and said, look, we are doing a lot of transactions in your country, but the question is, can you guarantee the political climate for the next couple of months? We have the same story, because the story is we have a constitution, the constitution determines, blah, blah, blah. But there is someone who is looking at the news, who knows the daily events that are happening. So they then have to put in some of these strong measures to say that, look, I'm going to heavily guard myself on events of default. I'm going to guard myself on the KPIs, right? So when you find approvers taking keen interest in some of those things, it is not because of them, it's because of our circumstances. Same thing with Kenya, same thing with Mozambique, Angola, where they are telling them, look, I need to get central bank approval. It's extremely difficult. It takes you a minimum of 6 months to get central bank approval in such transactions, because they are asking you, what are you going to use the money for? How comes it is not possible to get it from here? Countries like Tanzania, you cannot use those funds outside, or even them giving you security to be utilized outside. Why? Because their central bank plays a very key role in how those monies are used, how securities are used. Thank you.
Thank you very much, Gerald, for those insights. Very, very in-depth. And Cabrera, you spoke about regulatory risk. We recently handled a transaction where a money lender was borrowing money from across the border, and they got a license to operate as a money lender from UMRA. But remember, government had rationalized some entities, and UMRA has moved to Ministry of Finance. So the lender was very disturbed and was wondering, is this license valid? What do we do? So some of those are questions that come up when we are handling cross-border matters. And my question is, Cabrera, what regulatory approvals, notifications, or filings commonly arise, and what due diligence should local council carry out for the Ugandan corporate entities in that regard?
Thank you, Esther. In terms of approvals, and I'm going to, marry the two questions together. So we're going to look at corporate approvals. So those really stem from board shareholder approvals. Then you're going to, like I said earlier, we're going to look at, constitutional documents. We're going to look at, are there any license restrictions like I earlier mentioned, and also maybe sanctions compliance, which is becoming a very prevalent thing we're seeing these days, to just make sure that, that the borrower is not on any of the sanctions list. So that's what we're going to look at in terms of approvals when we're looking at the borrower. But then there've been instances when we've been tasked to do due diligence on the guarantor. So here we'll have to maybe engage foreign counsel, because we can't really opine about anything that is beyond our legal reach. So here things we're going to look at are, is the company validly existing under the laws of that side? Does it have the corporate power? Is the guarantee validly executed? And say, for instance, if they are, if the guaranteeing agreement provides for arbitration, has it been properly provided for? Why I say this is we recently had a case where we advised and we sought an opinion from counsel. And here in Uganda, if you've provided for arbitration and you've structured it the way it would, be considered to be a good arbitration clause, then you're good to go. But then let's not forget that could also be what I would consider a risk in terms of can we enforce, will they uphold, depending on what you've chosen in that regard. So it was very interesting to get Foreign Counsel's opinion to the effect that, yes, there's arbitration. We recognize arbitration in, say, Turkey. However, for it to uphold, there is a requirement for that arbitration to be provided or approved by way of, a board resolution. And so it was actually very interesting to then come back to our client and, state to them that, there's, you have this guarantee from this guarantor, but however, the arbitration, we will not be able to enforce because there's this requirement. So then we had to work backwards together with that Foreign Counsel to make sure that that arbitration was upheld. The other things, you would look at in terms of due diligence would be security-related filings. So here, like we'd mentioned, URSB, SIMPA, the lands registry, and also just stamping of key documents to make sure that they are admissible in court. But I will put a peg on that because of the recent amendments in law that have taken away, that now make, stamping zero rated. So how are we dealing with this situation practically to make sure that our client is actually protected and that indeed the security is enforceable? The other things we'd look at is sector-specific restrictions or, required consents. So we're going to look at telecoms, like I'd said, aviation, taking charges over, aircraft. We're looking at the mineral sector. Those are assets. So do we require consent from the Department of Survey and Mineral, And then we have oil and gas. Is there consent under, say, the production sharing agreement? So all this really pretty much covers, approvals, notifications, and also you'd have to look at that as a person conducting the due diligence. So I think that's pretty much it, unless, yeah.
Thank you, Kaburara. Natasha, I think you can, anything you'd want to add on in terms of due diligence?
Yeah, due diligence is a very, very key aspect of cross-border finance because, as has been described, cross-border finance is dealing with lenders who are not in country or borrowers who are not in the country if a Ugandan lender is lending outside the market. So the key aspect is to get to know the borrower. So part of the things, and Kabura has mentioned these, they are looking at the corporate structures of the borrower. They want to know, does the borrower have the structures in place to make the deal successful, the purpose for which the loan is given? Do they have the right directors? Do they have the shareholding structures? Are there shareholders agreements and the like? So DD looks at those aspects. In terms of licensing, the DD also looks at whether your borrower is licensed, and as Kabura said without repeating, is that you're looking at what consents are required from the regulators. You're looking at how do you then, due diligence phase feeds into your transaction. So you're looking at whether there are restrictions on, let's say, licenses that will help you structure your deal. For example, if you're dealing with a non-deposit taking microfinance institution, there is a restriction in the law from them creating security for loans of their shareholders, loans of third parties. So in terms of structuring, and what we usually see in cross-border deals is that it will be a group structure. So you find the group is in Mauritius, and then it has subsidiaries across different jurisdictions in Uganda, and those subsidiaries are required to provide guarantor security, to be guarantors of the shareholder loan. So if you're dealing with a non-deposit taking microfinance institution, you have to be aware of that. And the only way to do that is through DD, to know what restrictions are attached to their license. Another key aspect that we look out for in due diligence is lenders, existing lenders. You're looking at what lenders does this borrower already have? What are the terms of their agreements? Are there negative pledges? Are there restrictions on obtaining additional lending without consent? How this helps you structure your deal is, do you need to now factor in an intercreditor? Are you looking at, so if they are part of the lenders are shareholders, are you looking at subordination agreements? How then do you structure your documents. In terms of existing securities, you want to know how much security has your borrower created and how much more do you have? How much more are you taking? What restrictions do you have in those security documents? How does it affect your ranking? Are you going to agree to rank pari passu? Are they going to subordinate that security so that you take a prior interest depending on what the commercial arrangement is? Yeah, and then also you're looking at the asset base of the borrower. You're looking at what assets can I charge, what has been charged already, and what can I take. So in terms of DD, it strengthens the deal, it helps the lender get an overview of what the borrower's standing is. And also one last and very, very key aspect of DD and how it contributes to cross-border lending is that what you find in your DD directly feeds into what you're going to ask the borrower to provide as part of your conditions precedent. So if you look at the memorandum and articles and say borrowing powers up to a certain limit requires shareholder approval, then you know you will need a shareholders resolution together with a board resolution. So that feeds, your corporate would feed into your requirements. Your licenses, you would need to put a condition precedent, and condition precedents are these documents, information, confirmation, certifications that are provided by the borrower before the lender can actually disburse funds. Before the lender can give money to the borrower, they need to satisfy a certain set of requirements. So you're looking at licenses. Are these required to be renewed annually? So this also feeds into what undertakings you're going to put into your loan agreement. Are you going to require them to provide a license, an up-to-date license annually or whenever it's supposed to be required? Yeah. So that is it on DD and the key things that we look out for cross-border deals.
Thank you very much, Natasha, for those insights. Now that we've understood how cross-border financings are commonly structured, we've also looked at the risks, how to mitigate them, and we've also looked at the due diligence, what needs to be done before you do them. We're now going to move on to documentation, because that's a very important aspect of cross-border financings as well. Many times you look at an agreement, it's big, it's like 300 pages, and you need to review it to make sure you've combed everything. And for these cross-border financings, parties will usually want to ensure that their rights and obligations are well defined and predictable. So the choice of documents is very important, especially if you have lenders coming from the UK, from the US. They usually like to lean towards standard templates. And so on to my next presenter, Sheila. In your experience, jargons like LMA are very common among banking and finance practitioners. What are the most common documents you've interacted with, and to what extent are LMA-style documents used in Uganda cross-border deals, and where do you often see local law deviations or rider provisions?
All right. Okay. Thank you, Esther, and it's such a pleasure to be part of this esteemed panel of banking and finance lawyers speaking on a subject I know we are all passionate about, which is cross-border financing. Now, I think the easier part of your question is what common documents do I often see? And I think I'll pick up from the analogy that Cabrera, I'm trying to find the right name to call you today. That Cabrera picked up, which is the bucket. So I'll classify the documents into buckets. And there are mainly 4 buckets. So think of it like the first bucket really speaks to what the transaction is about. And those will be the facilities. So think of documents that speak to the facilities. So think of facility agreements, loan agreements, intercreditor agreements, hedging agreements that you talked about, the swaps, forwards, whatever. Those documents speak to the mechanics of the facility. So those you'll see different deviations, but really speaking to the mechanics of how the financing is going to work. The next bucket of documents would be documents that speak to credit support. And the easiest way to describe them in our market are the security documents. What are the documents that put the borrower in good standing? What are the documents that the lender is going to rely on should something go bad? So those are the mortgages, the debentures, which could be a general debenture, a specific debenture, charges over account. Recently, I think someone mentioned an earlier speaker about the notoriety of charge over shares. So those are documents that speak to credit support, and those are security documents, and also guarantees and indemnities. Now, there are other sets of documents, but they are really peculiar. It's the type of transaction kind of dictates what documents, the transaction will have. So if it's a project finance transaction, and I know we have a project finance discussion after this, and I don't want to dilute that discussion, but project finance, you'll find, has its own set of documents because of the peculiar nature of project finance. It's a type of transaction where the financing is really premised on the proceeds that arise from the project itself. So project finance will have a whole suite of documents which are, very different from the documents that you would ordinarily see in a normal bilateral syndicated transaction. So you would find direct agreements, you'll find the PPAs of our jurisdiction, that kind of document. But those are, again, dictated by the type of transaction that it is. And lastly, the other bucket of documents speaks to approvals. And I like that Cabrera mentioned that, that the first question you always have to ask yourself is, can this be done? Can this be done? Can the borrower enter into this transaction? Can the lender lend into this market? Can the lender lend to this type of market? So the next set of documents or bucket deals with approvals. So there are corporate approvals. Is a shareholder resolution required, or is it a board resolution, or is it both? Then looking at the security. Is it a mortgage over a lease from Kampala District Land Board, Uganda Land Commission? Is consent required? So those speak to approvals. She also talked about sector specific, that if you're taking a security over a license, for example, from a company that is licensed by UCC, you can't just create a security over that license. So you need approval or no objection from UCC. So that again speaks to approvals. So I think I would summarily say that the types of documents really depend on the type of transaction, but I think the 4 buckets that I have created would provide a good summary of what documents are required.
Thank you very much, Sheila, for that. And now, since we've been talking about documents, to what extent are LMS-style documents used in Ugandan cross-border deals, and where do you most often see local deviations?
Sorry, I forgot that. Yeah, so I would say from my experience, if it's a syndicated transaction, 100%. It will be an LMS-style document. And for the benefit of those who are on the call, who do not know what LMA is, and even for those of us who already know, but we need a refresher, LMA really is an acronym for the Loan Markets Association, which is a body of stakeholders in the finance market who realized that there were many inefficiencies with documentation. So they decided to come together and create a standardized legal agreements to make the process of financing much easier. So the LMS style documents that Esther is referring to are really templates that, in the banking world we use a lot, in the banking and finance world we use a lot to just make the process of documentation much easier, so that we are not arguing or negotiating boilerplate provisions. Instead, we leave the negotiation to more commercial points, so that we are not discussing whether non-payment of the principal is an event of default or not. So that we leave it to ratios and the nice things Gerald was talking about, swaps and the like. So that's what LMA came up with. And so the LMA documents in our market, if it is a commercial lender, if it is a commercial lender in a syndicated transaction, 100% they will use the LMA style document because of the benefits I have just alluded to. It's much faster to use the LMA style documents. Everybody knows what clause 2 talks about, so we are not going to discuss that. It makes it much cheaper for lawyers. I think if you have received a quote from English Council, they'll usually put language that it's LMA style, so that you don't spend too much time redrafting and renegotiating the document. They are trying to say, please be mindful that we are going to use a standardized document, so do not hike your fees. So those are the benefits of LMA. And I find that in our market, yes, to a very large extent, if it's a syndicated transaction, it's a no-brainer. LMA-style documents will be used. If it is a local bank, maybe lending it's a cross-border financing, still they will use LMA style. Now, LMA, because it's a template, it means that you can curate, you can tailor-make it to suit your transaction. And I think that's a misconception that we usually, borrowers usually have, or lawyers have, is that you can't force me to use this document. But no, it's just saying this is standard in the market because it's a tested and proven provision, but we can tailor-make it to suit your transaction. So yes, banks in the market, and Jared, I think, can confirm this, use LMA, or they have their own standard documents, but which are tweaked towards the LMA style documents. Now, when it comes to DFIs, just because DFIs, they have their own type of documents, but still, I would say, it still speaks the same language. It's the same spirit, and they would be still speaking to the same LMA style documentation. I think that's what I would say. You asked about riders in the local market, yeah. So all the tweaks that the local lawyer would put in the documents really comes in at the point that CPs, because, and we'll discuss this later, as a local counsel, you have to advise your lender on what this borrower should provide based on your jurisdiction to make this transaction bankable. So as local counsel, usually, the first page you run to review is, CPs, what CPs are required, and you edit, those provisions. But even in the body of the loan agreement, you will find that there are different provisions that you need local counsel support. For example, is stamp duty required? If it's a sovereign, you need to look at the immunity clause. Yeah, in some jurisdictions, you can't waive. To what extent can you waive? So yes, still it's a template. Yeah, but it can be tweaked or curated to suit your purpose. And I find that in our local market, that is a major role of us as local counsel, to tweak, even if it's an LMA style document, to suit our jurisdiction and the transaction.
Thank you very much, Sheila, for that elaborate discussion. And usually those LMA document templates, someone has asked what LMA is in full. LMA is Loan Market Association, and it's an organization that was set up to generally standardize documents. So as I was saying, since we've seen, those documents are usually governed by English law, and we've seen courts come up with decisions on enforcement, so we can't run away from the question of enforcement. And we've seen cases such as IRA, Investments versus Industrial Corporation Development of South Africa, which was a cross-border deal where IRA, a Ugandan entity, borrowed from IDC, which is a South African entity. And in that case, there was an issue on whether the lending agreements, that is the financial credit agreement, and the indebtedness of IRA was severable. So they had taken charges, including mortgages, and the mortgages were governed by local law, while the financial credit agreement was governed by English law. So that was a question that came up. And we've also seen another decision of the Great Lakes decision, Kabula Soke case. It's also a recent decision which spoke about whether LIBOR could be relied on to determine interest in a loan. And for all these documents, they were governed by foreign law that's not Ugandan. So it brings up the issue of, Sheila, how do you approach choice of law and jurisdiction clauses in transactions that have mixed Ugandan and foreign elements? And what are the trade-offs between Uganda and international arbitration?
Okay, thank you. I think the straightforward answer for this would be, remember the bucket of documents that I talked about, the bucket that speaks to facilities. So documents that deal with the mechanics, the facility itself, the mechanics, those types of documents will usually be based on English law, US law, that type of thing. So those facility documents will usually be based on English law. And I know that lawyers always want, the documents to be based on Ugandan law. But, if I'm putting, I don't know how much money into your company or into your jurisdiction, I want to use a law that I am most certain about. I want a law that has been tried and tested, especially on all the different clauses in the LMA style documents. So usually you find that that bucket of documents that speaks to facilities will usually be governed by English law or US law. And then the second bucket of documents that deals with credit support, usually the security documents, will be governed by local law because security is most important at the time of enforcement. So I want to use Ugandan law because at enforcement I will go on ground. I'll go to Uganda and actually sell the property. So usually I find that, unless anyone has seen a different position, I find that the suite of documents that speak to facilities will usually be governed by English law, and then the local Ugandan law will be used to govern the security documents. In terms of dispute resolution, because again, our Ugandan courts, it takes forever to even just decide something very small again. And generally, because these are commercial contracts, we need it to be concluded in a very short period of time. We find that bucket of document that speaks to facilities will usually use arbitration, hence the popularity of arbitration now. Yeah, so it's sometimes the dispute resolution is dual. It can be court and arbitration, but I think increasingly I'm seeing that it's mainly arbitration. And then for the security documents, most lenders are fine for you to use court. Yeah, that would be my.
Thank you very much, Sheila. So we'll move on to our next discussion point, but still related to enforcement. Now, since New York and English law are centers of international banking, most of the arbitration clauses will refer that arbitration is done in those laws. And Gerald, as one of the top players in the lending space, what's the current market experience when it comes to recognition and enforcement of foreign judgments and arbitral awards against Ugandan counterparties?
Okay, so that's very interesting. When Sheila was mentioning something, I remembered the story, right? You'll indulge me. So a couple of years ago, we had a transaction that was going to be governed. We are going to use LMA documentation. We are going to, it was going to be governed under English law. So the question was, we are instructing counsel. By that time, we were instructing counsel from London. So then the client reached out to, I think the RM was asked, who is the lawyer dealing with this? Said, some guy in London. So then they said that's impossible. So over and above that was the invoice. So when we gave him the invoice, said, let me talk to the person who brought the invoice. So that's how we got my phone. So he called me and said, we have lawyers in Uganda who are qualified in English law. Are we able, or are you telling me that those guys cannot draft an English law document? And to be fair, he had a point. So I wasn't also very bad. The employee I went to my boss at the time. I said, look, are we able to give a consideration and a risk acceptance? The first question that my boss at the time asked me is, I have no problem giving you a risk acceptance, but if you are putting money, you're putting $150 million, you bring it from wherever and putting it in Uganda, are you going to trust that there was a Ugandan who is qualified in English law. Are you going to trust? I didn't have an answer because my boss told me if you have an answer, you're getting the risk acceptance. But that's a story for another day. I just wanted to touch on the aspects of LMA documents and whether they are acceptable before I go to the question you've asked. I think from a banker's perspective, from a lender's perspective, and you really see that there was a trend that is happening. You have, I will use the word that Kabzi and Sheila have used, buckets. So borrowers, you can bucket them, from a corporate perspective, you're bucketing them in these buckets. You have the large and local corporates, who are our local indigenous customers here. Then you have the multinationals, multinational entities, who are those companies that are incorporated outside, and then they have, by virtue of their financials and all that, they then qualify to be multinational. Then there are those ones who are global multinationals, who are beyond that. So in terms, when you're dealing with a large and local corporate and you're giving them LMA documents, the first question that they will tell you is that this document is too voluminous, because it means that he's going to have to instruct counsel to then look at that document, and more often than not, you have counsel who will then come up and say, okay, let's amend this, and you find that the lender is not comfortable to amend some standard clauses. Then, obviously, then you have, when you have the multinationals and global multinationals, they are used to these documents. It's their daily bread, so they know, because they are part of the negotiations, most likely. Now, then you go to the clauses in those agreements, and that's what Sheila was talking about earlier. Some of the clauses that you then find a little bit of pushback when you have lenders' decisions, for example, in syndicated transactions. Who is qualified to make the decision? Is it a majority lender? Is it what is the decision-making mechanism? And you would find a minority lender who would then come in and say, no, I want a 50% share, 50-50. You cannot sit in your high office and then you make a decision, and then me, I can't make that decision. It's a good decision, it's a good initiative, but when you think about it, a majority lender is not going to allow you to distort the entire facility, all because of a court case, or a court case where you've gotten about 300 million Uganda shillings. Yet the relationship is worth $30 million, right? So you have that kind of arrangement. Then you have events of default. Natasha here has facilitated LMA trainings. I remember one LMA trainer mentioned and said, if you ever have a borrower who is negotiating events of default, then that is the point where your antennas need to be high up, because even before a disbursement, someone is already looking at an event of default, right? So not to say that you don't look at them or you don't negotiate them, but there are certain standards that you also have to look at, both from a borrower's perspective and also from the lender's perspective. And quite frankly, the lender has a lot to lose in the transaction, right? Then obviously the one that is very important to our colleagues in government is waive of immunities, where they really, really try as much as possible to negotiate. But from the trends that I've seen, I think it will depend on the person in the office. There are some who are quite reasonable, then there are those ones who take a very hard stance, but that is also one of them. Obviously, then there was the choice of law, and then there was the arbitration clause, right? So that document, I think as Standard Bank, and I think other entities, other DFIs, you would find that they have tried to lean the LMA document, they lean it into a much user-friendly document. But by and large, I think LMA gives you the standard. It doesn't mean that you can't change it, but then it doesn't mean that you blame the banks when they can't change that standard, even when it is amenable, right? So I'll just move to the enforceability question that
Sorry,
you
Gerald, before we move on.
Yeah, I just wanted to add something, sorry, that when you said LMA has a standard, just to also emphasize that LMA for our market has a standard for the security document, yeah, which in my experience is a very good starting point if you need to draft a security document from scratch. It's called the NIAS, yeah, Nigeria, it's an acronym, yeah. So it's an acronym, but it really speaks to our market. So if there is anybody, if you need to draft a security document from scratch, the NIAS security document would be the best, a good starting point. And it was really done extensively. I know, Natasha, that's your farm. And it takes into account the different security laws, that affect Uganda, including SIMPA. So I just wanted to mention that in case I forget.
Okay. So I'll quickly just go to the question on enforceability. And you can never talk about enforceability without talking about the due diligence that I think Natasha had spoke to and Cabrera, right? Because when you have your normal hard securities, you have land, you have the debentures, that means you've already done your search, you know what is entailed on that security. So enforcement on those could be a little bit easier depending on what are the circumstances on ground. But I'll just speak to the one on corporate guarantees, because corporate guarantees is what we are seeing mostly from a corporate and investment banking field. And you're taking guarantees, whether it's from China, the ones that we normally see are from China, from South Africa, London, and Australia. So you then have to ask yourself, over and above your due diligence of the borrower, what due diligence have you done on that person? And even it will matter a lot that you have a legal opinion, because then that legal opinion will have a clause on it, right? So if it has that clause on enforceability, you need to make sure that before you actually sign off that legal opinion, you're comfortable with the level or your understanding of enforceability of that corporate guarantee. Even when it is regards to shares, right? If you're taking shares in a different jurisdiction, there are those steps that you would have to understand before, yeah, where you, if need be, have you sought of any authorizations, etc. So that is what that's under enforcement. Due diligence is very key. Before you enter the transaction, it will help you during the enforceability process.
Thank you, Gerald, for that exhaustive discussion. So now that we've talked about the facility agreements thoroughly, we're going to briefly talk about securities. And Linda in the morning gave a very exhaustive discussion on what kind of securities are taken in Uganda and how they can be registered. So I'll just ask Natasha to quickly tell us, from your experience, Natasha, what are the common securities and what kind of challenges do you face?
So in terms of securities, and just to avoid repeating Linda's presentation, I think she did a very good job. The common types of securities you come across in cross-border transactions are the typical securities. You find a mortgage, you have debentures. Lately, there's been a rise in deeds of assignment of receivables. There are share pledges, there are liens, and the like. There are a number of security documents that you can take, guarantees and the like. The challenge that we have now and how the security documents play into your role as counsel on these transactions is you have to look at the risk that comes with each security document. You have to consider the lender's purpose. So you find that some lenders are happy not to take security because in cross-border financings and after the DD has been done, certain lenders take the position that the borrower is reputable enough and they trust that they don't need to take security over it. This is very common with the Chinese lenders, DFI, development finance institutions, some of their policies are not really to stick to the security. They are not looking at default. They are looking more at the purpose for which the loan has been given. So these are considerations that you take into account as lender on a cross-border deal. So if a lender comes to you and they are willing to take only a guarantee from shareholders, you cannot insist that, no, like, what if the shareholders are not able to pay? Let's take a mortgage, let's take a debenture, let's take a deed of assignment, let's take their chattels. No. So some lenders' policies are to take a very liberal position in terms of security, while the commercial banks, like my colleague Gerald here, they are looking at what do I get when the borrower does not pay. So they will take all sorts of security. Almost even the laptops. No, yeah. So they will take all sorts of security, and yeah. So these are things you look at. Impact, you look at the type of financing. In project financing, the taking of security is over the project assets, but the purpose is not necessarily to enforce against those assets, but the purpose is to just keep the lender knowing what assets are in place and that the company has the assets. But it's rare, because the lender's purpose in project finance, and I don't want to preempt the following discussion, is that the project will succeed. And that at that point when it succeeds, the project company is able to pay back the lender. So these are considerations you take into account. In terms of perfection and the problems that are facing practitioners in Uganda currently, I'll start with the one that was discussed in the morning, the share charge. So the share charge is a very common security in cross-border dealings, and it's very highly respected in other jurisdictions. It's very highly enforceable. In fact, we've had lenders who come to us and they just want a share charge. They don't want the mortgage, they don't want all these other securities that are common in the Ugandan market. The challenge with that security now is, one, we have a restriction in the law. Historically, that restriction was not there because with the coming of the Security Interest in Movable Property Act in 2019, before that we were able to put a clause on deliverables under share charges. So one of them would be a signed transfer form. This also came before the automation of systems at the company's registry. So you would have that form beforehand. You'd be able to register it 5 years down the line. Right now, one, we have the illegality in the law. You cannot execute a transfer as part or as a condition to a loan. So one, that is a restriction. Secondly, the practicalities of how the system works right now. If you were to take that transfer form, ignoring the law, you generate it in 2025 now, meaning it would remain as an application in that borrower's account until 2030. But the borrower can delete it, yeah? So the practicality is just not there anymore. And also, to generate that form, you need to fill in the details of the person you're transferring the shares to, which is not likely to be in place at this time. So there's a challenge there with the share charge. We are trying to advise clients against it, but I mean, going back to the discussion I had earlier, on the purpose, you have to look at the reputation. Some lenders now are happy to just take out that requirement. So you don't do the transfer form, you do the power of attorney, you get an undertaking from the company. As and how you get that done when the borrower is in default is that we are yet to see that happening. I think also another challenge we have in Uganda is that there's very little jurisprudence. There are very few cases that speak on enforcement of certain securities like debentures and shares and the like. So those are things you take into. Then also one other challenge we have is, do you go with wet ink signatures? Are we still taking wet ink signatures? Are we moving with the Electronic Signatures Act? You would think that we have moved on. Unfortunately, you present your document to certain authorities that I will not mention. Yeah, and they'll tell you, give me the original. Even now, the other authorities that have moved to electronic, they'll tell you this is a pasted signature. You will have a query that this is a pasted signature. So are we advising our clients to still give us wet ink, you know? And you don't want to look like a jurisdiction that is not moving with the trend. So unfortunately, we still have to get wet ink signatures, even though we have moved towards the electronic. Another issue we have is timing. So the Stamps Act says, because these are cross-border, you will have signatures coming in from different jurisdictions. You have the Stamp Act saying you have 30 days from the date when the signatures arrive in Uganda to complete the stamping process. If you have a debenture or a mortgage created by a company, you have 42 days to register your security. Meaning if your signatures come outside that time, then you have an issue of applying for extension of time. But we are happy that URSB has put in place a mechanism where the application for extension of time is really swift and you're able to get that out quickly. Also, another consideration that we take into account when dealing with securities, this comes into place when you're dealing with refinancings, where the question arises, do we take new security for the new amounts? Does that restart the hardening period? The hardening period being the voidability period. If you create a charge, if a borrower creates a charge within 1 year preceding their insolvency, then it's void. It's a void charge. So what do you tell your client? Do you tell them to take new security with the risk that you're restarting the hardening period, or is it looked at as a continuation of a previous security? Unfortunately, we have to take the risk. When you create new security, it is a new charge. It is a new charge. Except where what we've done, the exception is that if it's a refinancing and I'm buying, and the lender is buying another lender's debt, and they're taking benefit of the previous security, then we're happy to advise that there's no hardening period restarted there. So those are just a few of the key considerations taken into account when you're dealing with securities. You're dealing with the securities that a borrower should give on a deal.
Thank you very much, Natasha. Now, Sheila, since we've been discussing challenges, there's one challenge that we usually face, and it's in line with SIMPA. SIMPA, when you register, they'll usually ask you the tenor of the loan, and then you'll put, like, say, if it's 10 years, you put 10 years. But we've seen scenarios where maybe the lender extends the tenor of the loan without coming back to you, and yet the way the law is structured, it says you have to amend before 6 months expiry of the security interest. So we have many instances where the notice lapses, and then the lender comes later and you realize, oh my God, this notice already lapsed. Sorry, someone is asking what SIMPA is. SIMPA is the Security Interest in Movable Property Act. So under there is a Security Interest in Movable Property Registry, and that's where we file all movable charges, the deeds of assignment, the debentures, the charge over shares. That's where all those are registered. So my question to Sheila is how you'd handle such a scenario.
Thank you, Esther. I think it's everyone's pain point. When you think about it, your charge at the company's registry has no expiry date, despite the tenure of the loan being 7 years. Your mortgage at the land's registry has no expiry date, despite the tenure of the loan being 7. So you wonder why SIMPA was being creative to put an expiry date, yeah? Because, transactions, these financing transactions, as you rightly said, there is usually amendments, all manner of things. And I think that's why, those other public registries would not have an expiration date for the security. So I think it's one of those things. What we do is to tell the client that, this is a challenge that we have in our market, that this particular public registry has an expiry date, yeah? And therefore, going forward, if there's going to be any amendment in the tenure of the loan, any manner of amendment, please let us know, so that we can then evaluate if it needs, if the notice at the registry needs to be updated. I think in the transaction that we handled, we actually reached out to SIMPA, and they said it's something that they are considering maybe removing, but it's the system as it is now was developed that way. Yeah, that way, and Ugandan things, until they need to renew the contract or whatever, at the next level of renewal or updating the system, they will consider that. But I think for us as banking and finance lawyers, our role is to tell the client, they make the credit assessment, you have discharged your burden.
Thank you very much, Sheila, for that. We're now going to move on to another interesting area of banking and finance, and that is ESG. So we've seen that there are many climate disruptions going on. There was a recent disturbance in Jamaica, and it destroyed so many things. And even here in Uganda, there are so many floods going on downtown. Yeah. So imagine as a bank, you have borrowers, and borrowers own businesses downtown, and their shops have been flooded, and you can see there's nothing to do about that. As lenders, I know that UBA has come out strong on trying to come up with a framework that guides ESG. And so, Gerald, from your perspective as a lender, tell us about how Stanbic is spearheading green financing and what they are doing generally about the environment. Because even for cross-border financings, if you have a lender like IFC, definitely you'll have clauses on environment standard in there. So we can't run away from the environment. It has come for us, and we have to address those issues.
Sorry, so I think ESG, I think, is touching a lot of aspects. You'll even see from procurement contracts that some of these corporates are making, they have those standard ESG clauses. Same thing with our facility letters. And I think even LMA, I think, has also included some of those compliance clauses to ESG. But I think in terms of green financing, I think Stanbic, among other banks, I think, has gone a step higher to try and see what contribution it can make in this field. It is quite clear, and one of the criticisms is that there is no standard whereby a project may be green, and then to some other person it's not a green project, right? So there was a standard that needs to be aligned, and I think that's where the discussion is, to the extent that you run a risk of someone saying that I'm going to create an eco-friendly kind of project, but then the output is even more injurious to the society or to the environment. Yeah, but I think as a bank, I know we have a renewable energy portfolio within our BCB department. It's usually ESG in full is environmental, social, and governance. It's more of an acronym that I think has been developed, and it is evolving. It's something that is evolving over time, and it's going to be here with us, right? Because of the changes that we are happening. But that is just environmental, social, and governance. Yeah. So that's what it is in full. So I was just mentioning that I think as Stanbic, under our BCB portfolio, we have renewable energy loans, which go to, I think, some of the areas where you will have seen is solar improvements. Some of the entities that you have, like Centenary, is also involved in that area. UDB is also involved in that area with regards to automating farms or agriculture. So you see that there are certain players who are coming in to create that. The only criticism that I have mentioned is that even when we know that ESG is a thing, we are dealing with it now, there is no particular standard. You cannot say, for example, that this project is a green project, because it will have nuances, but then there are certain things that would then disqualify it in one way or another. So the criticism there has always been that there is no standard. It depends on how I perceive it, say, as Bank X, and then Bank Y would say, look, that may not qualify based on my risk appetite, how I see it. But that's the role that we are playing as a bank. And I think if you read our report to society, which is issued on a yearly basis, you would see that in 2024 alone, we had over 90 billion in loans in just this area, green financing. And you're not even including the loans to women groups. You're not including loans to some of these agriculture initiatives that we have. So those are some of the areas that we are playing in, whether it is women developmental groups, agriculture, solar energy. We are trying our best to try and penetrate that, to try and give at least a contribution to the society in as far as ESG is concerned. What you have to note is that it's one of those growing areas that we are looking at, or that one would look at. Like I've already mentioned, whether it is procurement contracts, you'll see those clauses. And one of the features of some of these, there are two types which I could speak about very briefly. There's sustainability linked loans, and then there was also the green loans. The green loans are tied to a very particular or specified purpose. That's why you see that it will go to, let's say, solar, eco-friendly development or mechanization of or automation of your agriculture systems. That's where that loan would go. And that's one of the things that would qualify that loan to be a green loan. It goes to a very particular eco-friendly purpose, right? Then obviously your sustainability linked loans, those ones are purely general corporate purposes. So those ones are simply that. I know there was a lot to say about this, but under ESG or under green loans, the KPIs are very important for the individual, for the borrower. If they tell you you have to have met a certain threshold or certain KPIs, those are the reporting. So your KPIs are key, and also the monitoring is key, because from a lender's perspective, it could easily be an event of default if you're falling short on some of those KPIs or monitoring measures. Yeah.
Thank you very much, Gerald, for those insights. So before we close, we can't go without talking about sovereign borrowing. We talked about general cross-border borrowing, but we can't ignore the fact that government also borrows. We've been seeing in the news all this noise going on about how we keep borrowing, yet we have too much debt. But anyway, that's besides the point. So it's important for us to understand that government as a borrower has unique, when borrowing involves government, there are unique features about that borrowing that I would like Sheila to highlight to us.
All right. Yeah. When we said we're going to talk about borrowing by government of Uganda, I won't tell you everyone's reaction on this panel. But yes, borrowing by a sovereign or a state is very different. Very different in terms of the approvals and the process that goes into it. There's one spirit, but the mechanics of how sovereign borrows is a bit different. And I'll just speak high level on some of the things that you need to be thinking about, and in respect of government of Uganda or any other sovereign body. So the first thing you need to be thinking about is what we started with: can government do this? Yeah, you always have to ask yourself, can government do this? If they can do this, how do they do this? Who is going to be, how in the normal corporate transaction it would be the director signing? Your question then would be, if it's government signing, who is going to be the director to sign these documents? Which is why I said the spirit is exactly the same. It's just you have to tailor make, the different documents or persons based on a sovereign. So having established that, can government do this? I remember in one of the transactions, a question from one of the lenders was, can government of Uganda borrow from their type of entity, because many borrowings, it's a commercial bank, it's a DFI, but this was a different type of entity. And their question was, is your government allowed to borrow from our type of entity? So obviously you would check the constitution and find the provisions. How does government borrow? Having established that government can borrow and can borrow from that type of institution, the next question would be, how does government borrow? which parties, which offices are you going to interface with in order to ensure that this agreement at the end of the day is enforceable. So the office you would likely interface with is the Ministry of Finance, yeah, because under the Public Finance Management Act, the authority or the mandate to raise loans on behalf of government is with the Minister of Finance. The second question you would then, but again, government is very special because under the Constitution, government doesn't just borrow, you know. There has to be a legal opinion from the Attorney General's office, and that's Article 119 that says every agreement that is entered into for and on behalf of government has to have a legal advice from the Attorney General. So again, that's an office that you're likely to interface with, the Attorney General's office. You'll need to see that advice, and many of these documents that I'm talking about become the CPs that Natasha talked about. So you'll find that the CP schedule of a sovereign loan is very different from a CP schedule of a corporate, because the different documents that would render the different documents and approvals that would render a sovereign financing enforceable are very different from those of a corporate entity. Then government is also special because there is parliamentary approval. So as a lawyer advising on a sovereign, you have to ensure that the parliamentary approval for the borrowing is also in your file or among the documents. And with borrowing, you know, with government, it's political. It's usually charged with politics and the like. So you always, you know, you always have to be mindful about the approval process. Is it going well? I think in one of the transactions that we were handling, which was a sovereign, it really, I think that's the most we read about parliament proceedings, budget approvals, because all that feeds into the process. You want to make sure that at the end of the day, you're telling your client that this borrowing by government went through the entire process. And so as a lawyer, you need to know each of the processes. It's a bit bulky and a lot, but thankfully our friends from the Ministry of Finance are quite helpful, but it's different, is what I would say. So as a lawyer, think of who can government do this, how do they do this, who is signing. You also have to think about immunity, because that's the biggest, I think, negotiated provision. Now, you know that under a corporate entity, if it's a corporate entity borrowing, in your legal opinion, you say this entity is not immune from its assets. It's not immune from suits. You can attach its assets and the like. But government is very different because, and you've heard of all these stories. Zambia, they've attached sites of natural resources. There are stories of Tanzania, where an aircraft was attached in Netherlands. So in our law, we do have, they are protected assets, and I would encourage everyone who is interested in reading more about this. We have, I think it's an instrument under the PFMA that clearly government of Uganda has said, yes, I can enter into a contract with you. If it goes bad, you can sue me, but you cannot attach X, Y, Z. So as a lawyer advising a lender or advising government, you have to be mindful of the extent of the immunity and tweak our LMA document to speak to that, to what the law provides. That's where the local council role comes in, that you can then tweak the LMA, which says you're not immune to, say, subject to the law of PFMA. I think that would be my thoughts on that.
Thank you, Sheila, for those insights. Now, as we wrap up, I would like to ask my panelists, I'll start with Natasha, and then Gerald, and then Kaburara, about what market developments you think are likely to shape cross-border financing in Uganda over the next 12 to 24 months, in your opinion.
I'll just start with where we are now. I think the space is looking good. We've seen government support for borrowers by reduction of taxes to encourage borrowing. We've seen automation of systems. We've seen courts and different regulatory authorities pronouncing themselves on legalities of transactions of this nature. So it's looking good, and I know that it's going to just look better. I know that there are a number of projects coming up in Uganda. We have the oil, which is taking a whole stride. We are looking at our airport expansion. We are looking. So I believe that there's going to be a lot of project finance. What I know right now is that the hold off has been elections. There's a tendency for lenders to first hold and study the situation until after elections. But I am very confident that after the elections, there's going to be an uptake. There's a lot of agricultural financing in the market. Banks and even cross-border lenders are taking an interest in agricultural financing. So I see that there is going to be growth. There is very good traction so far with where we are, and I know that it's going to only look better in the few years to come. Thank you.
Thank you, Natasha. Over to you, Gerald.
No, I think I have two. One, I've spoken about it, which is ESG, but the second one, which is now a pain point, I think, for most of the financial institutions, I think is tax related. Transfer pricing is a very big issue that has come up. So ideally, you literally have to understand your mechanism and your model of transfer pricing, because it's still a very shaky ground, but I'm very sure in a couple of months we may actually have a more streamlined process. But transfer pricing is a very key thing, as well as ESG. Those will be my two.
Thank you, Gerald. Over to you, Cabrera.
Thank you, Esther. I think mine would really come from the National Development Goal 4 and also the tenfold growth strategy for Uganda. So there have been so many conversations on how we're going to leapfrog towards becoming that 500 million, economy. And so for me, where I see a future is with regards to blended finance, whereby we're going to see a lot more activity in terms of the mix, where we have development partners together with our commercial banks. And also we've seen a lot of activity in terms of Pan-African and regional lenders. So that's where I see us going. Thank you.
Thank you, Cabrera. And now, Sheila, lastly, if you could change one policy that would make it easy to do cross-border financing in Uganda, what is it that you would change?
If I could change one thing to make cross-border financing easy, I thought about this, and not that I'm a poster child for LMA, but I think that if the players in the market got well acquainted with LMA-style documents, it would make cross-border financings much easier. I think it would, the transactions would end much quicker, and that benefits all of us on the transaction, because as Gerald had talked about, you'll find that a big borrower, but let's say their internal legal team has never interfaced with an LMA-style document, but they are in a syndicated transaction involving a number of commercial banks, and as to what document is being used, it's a no-brainer, yeah? But pushback is coming on events of default from, internal counsel. So, and not to say that all internal counsel, but I'm just giving an example. Yeah, but I think that if you are to do well in the cross-border financing space, I think that you can't run away from LMA. And lastly, I think that a lot of the financings into our market are heavily hinged on security. And so we rely a lot on our public registries to make our work easier and to make the work of to make the financing, to make the deal go through. And so when you submit your charge for registration at a company's registry, and you think that the company's registry, and you get so many queries, and the lands registry, those kind of things, they create problems. So I think my other thing was that if the lands registry, just like SIMPA and companies has gone electronic, if the lands registry would also go electronic, I think we would all sleep better at night. Yeah? Thank you.
Thank you, Sheila. And to build onto your point, what I would change would also be in respect to the registration. So for SIMPA, we have, for securities over immovable property, we have to register both at SIMPA and also using the OBRS portal. And sometimes it's very tedious. The lenders wonder, why are you doing double registrations? And yet it's the same entity. So I'm praying that the regulators will, will look into that and see how they can help to make it better. So as we wind up, there are a few questions in the chat that we can quickly answer before we close. And the first question is, someone asked if we could please speak to crowdfunding that may involve cross-border players and the roles of each party. Sheila, can you kindly answer that?
Yeah, okay. Disclaimer, I'm not an expert on crowdfunding, but I know a bit to speak to it. So crowdfunding is similar to syndicated financing, but someone would have, so someone comes up with a project, a project that, people are interested in. So think of it like different people in the public are interested in that project. An online platform is created where, think of them as investors, contribute their small amounts of money towards that venture or that project. So that's why it's called crowdfunding. Different members of the public read and are interested in the project, and then there is an online platform where they make their small contributions onto that for that project, so that the project then takes off. Different players, obviously, starts with the entrepreneur, I think, the person who comes up with the project, right? The concept, the one who comes up with the concept of the project, that would be one of the players. Another players in some markets, because it involves taking money from public, the regulators are heavily involved in crowdfunding. Definitely there is a public, there is the one who comes up with the online platform where these different investments would be made. Then there are, these third parties that make the payment possible, that make the contribution possible. So think about it like a syndicated financing, smaller value contributions from the different would-be investors. And I think the most important difference is that it has an online platform where different members of the public would contribute.
Thank you, Sheila. The next question is, where is the line drawn between ADD and credit appraisal? Gerald, could you please speak to that?
Okay, so quite simply put, is that your due diligence oftentimes will support your credit appraisal, because you cannot appraise someone that you don't know. So you literally have to know who the borrower is, who their promoters are, whether their reputation, and then you come down to the nature of their security. Have you researched about it? So that then forms part of your submission to a credit, to your credit committee, to then consider and say that the person who is behind this person has, because you even have to have done your due diligence will go up to researching about the different individuals, whether there is any adverse media about them. So oftentimes your due diligence supports your credit appraisal. You have to do your due diligence first before you then appraise that person. I wouldn't advise you to do a credit appraisal without doing due diligence. Yeah, thanks.
Thank you, Gerald. There is another question, and Sheila, you'll address this. And the question is it only international arbitration that the parties usually refer to in these cross-border agreements?
And I assume you're referring to the bucket that deals with the facility documents, right? Yes, so in that bucket of documents, yes, it is usually, in syndicated financing, it's usually international arbitration. But I think there is nothing wrong, or there would be no restriction in using local arbitration. I think with these kinds of transactions, lenders or investors want to use a law or a system that is tried and tested. So if your local arbitration, and are comfortable, yes, if your local arbitration regime is tried and tested and are comfortable with it, then definitely they would use it. But to answer your question, it's only international arbitration I have seen so far in the facilities bucket of documents.
Thank you, Sheila. The next question is about how do you negotiate pricing for banking work that goes beyond the usual fee caps, especially in situations where multiple reviews and delays by Ugandan regulators result into additional work for local council. Natasha, please address that question.
Well, in terms of pricing, I think one, there are certain fees that are common. Like it's an unsaid rule, but once you put in your quote, you will either look like you've understood the scope of work or you have not understood the scope of work based on how much you've quoted. So one, you need to understand the market rates, and that's where you float around. Two, you need to keep a timesheet. For cross-border deals, there's a tendency for them to spill over. The work spills over naturally. And if you're dealing with regulated entities, it's even worse. If you need consent, if you need approvals from different government agencies, you have to factor that in your billing. Two, at the time of quoting, you need to put assumptions. You need to put timing assumptions. Having worked on transactions of that nature, how long did it take? What is your experience? How long are you going to take to get the approvals? So put in your timing assumption and say, instructions shall close within 6 months. After 6 months, we shall charge our hourly rate, or we shall charge a monthly cap of this much. So that helps you negotiate. But also it comes down to how you run your transaction. One, you have to have timesheets. You have to know exactly what you've done on a deal to be able to ask for more money for it, because sometimes there are gaps in cross-border deals. There are gaps where they say they are getting approvals from another jurisdiction, or there has been a delay with one borrower in like Mozambique who has stalled the transaction. So you need to factor that time in before you increase your cap. But it goes back to communication, it goes back to proper record keeping of your timesheet and what you've done on a deal. You have to be a bit organized so that in the event that you want to bill more for the additional work, you're able to say this was not part of scope, but also to understand your scope so that once immediately a new instruction comes that falls out of scope, you're very quick to say this was not covered in the initial scope, as such you shall be billing this much money. So it's just about how you manage your communication with your client and also being able to show the work you've done and how the new instruction falls out of the scope that you originally quoted for.
Thank you very much, Natasha. There is another question. Are you seeing cross-border financings where there is no guarantee or any security, basically unsecured loans? I'll ask Kavara to answer this one.
Thank you, Esther. Yes, we are definitely seeing cross-border financings where there is no security, but this really depends on the borrower, and it is informed by rating agencies or rating companies such as S&P. We have Moody, then we have I think Fitch. Yeah? So these rating agencies rate the creditworthiness of the borrower, and the borrower could be a sovereign, it could be a multilateral, it could be a highly rated, company. So what they will do is that they're going to focus on, like I said, the creditworthiness of the company. However, that doesn't mean that, that because it's unsecured in terms of collateral, that it's not typically unsecured. So how we've seen it being structured is you'll have like negative covenants or negative pledges within, say, the finance documents, where you pledge that you will not offer, the security or the financing to any other lender. We've had covenants on financing ratios, on reporting obligations. We've also seen instances of maybe there's a guarantee if it's a company within a group, and then I forget the rest, but yes, they do happening, yes.
Okay, thank you, Cabrera. The last Ugandan laws prohibit lending to projects that have significant environmental effects, even when profitable. Gerald, over to you.
Okay, that's a very interesting question, but it depends on first of all, it's the nature of the transaction or the nature of the project, but then also the reputation that the financial institution wants to be aligned with, because some of those aspirations that a financer has, for example, if you have I'm not going to name names of projects, but I'll give you an example. If you have a project that then affects a particular species of birds, or it affects the environment in a particular environment, it's more likely that you will not get financing from some of these international financial institutions, because they are all up there on ESG, environmental friendly. So they'll guide you to ways on how your project, even when it has that bad impact on the environment, how you can make it better. They will direct you to probably advisors or even consultants who will then guide you on how that project can be made slightly better to the environment. But there is no law particularly that will tell you don't lend, but it depends on the financial institution to say, I will not lend you because of X, Y, and Z, right? Yeah.
Thank you very much, Gerald. And at this point, I want to thank the Uganda Law Society for giving us the opportunity to share our knowledge with the participants who've joined in. And thank you all to the panelists who are able to take off time to come and present. Thank you.
Welcome back from that very insightful session. I know that we have been able to learn a lot from that particular session. I won't regurgitate what has been already said, but to just transition us into the next session, because I see time is not on our side. So our next session shall be project finance in Uganda. That is the last session for today. And our discussant for that particular session is Miss Patricia Kamugisha. And I have the honor of introducing her. Miss Patricia is an associate partner at Kampala Associated Advocates, that's KAA, working across the banking and finance, corporate advisory, commercial transactions, and energy and natural resources departments. So she has over 10 years, and with that over 10 years experience, she is a trusted legal advisor to leading Uganda financial institutions, adept at handling transactions involving security perfection, security sharing arrangements, syndicated loans, and security documentation audits. Her expertise in project finance is further strengthened by advising on electricity and infrastructure projects and attending specialized trainings in infrastructure and project finance. Patricia's experience extends beyond finance, covering employment, climate finance, corporate governance, estate planning, and immigration matters. She provides legal opinions on validity and enforceability of securities, and her work includes advising on sophisticated loan and credit facilities, regulatory compliance, insurance, and corporate structuring. Of course, her education background goes without saying. She holds a Bachelor of Laws degree from Makerere University, postgraduate diploma in legal practice from Lord Volman Center, and has completed a master class in infrastructure and project finance, as well as a postgraduate certificate course in mechanics of loan documentation from Middlesex University. Welcome, Patricia. She will be taking us through her presentation.
Good afternoon. Yes, thank you for the introduction. I know a lot of time has been taken up and we don't have much time, so I'll be mindful of that in my presentation this afternoon. What I'm speaking to you about is project finance, particularly from the Ugandan perspective, and my presentation is going to cover what exactly project finance is, when project finance is appropriate, the key features of project finance to enable us know and differentiate it from project finance and corporate financing. I'll also walk us through the typical project finance structure and discuss Ugandan case studies to give us insight into the kind of projects that have taken on project financing, and also enable us have a distinction between other kinds of financing. I will also cover the finance documents that are relevant in project finance, the risks that arise in this kind of transactions, and the mitigation strategies that are implemented. Time permitting, we'll also look into the pros and cons of project finance, the challenges and the success factors, as well as the opportunities for lawyers in this space. I will now move on to define project finance. The International Project Finance Association has defined it as the financing of long-term infrastructure, industrial projects, and public services based on a non-recourse or limited recourse financial structure where the project debt and equity used to finance the project are paid back from the cash flows generated by the project. So I'll just break this down. You see, it's about long-term infrastructure. We are talking roads, we are talking dams, we are talking hydropower projects. The non-recourse or limited recourse aspect, which I will expound later on, is essentially in relation to the fact that if the project goes wrong, the lenders do not go against the sponsors of the project itself. They go rather for the asset and try to recover as much as they can out of that. I'll now proceed to take us through when project finance is appropriate. When is it good for sponsors to look into getting project finance? If one is getting into a large and capital-intensive project, a lot of money is needed relative to the sponsor's asset portfolio, then project finance is something that can be considered. Maybe a big upfront investment is needed for a project like a road or a hydropower dam. Then the entities that are interested in such kinds of projects can seek project finance. If an investor is coming into a risky or unfamiliar jurisdiction and they need some sort of mitigation of the risks, maybe they fear the jurisdiction they're getting into is unstable and they need some sort of satisfaction that their project is not going to fail a few years down the road, project finance is something that can be considered. Project finance can also be considered where we are dealing with joint ventures of partners that have unequal financial positions. Maybe one of them has less money and they're not able to handle such a project on their own. Their capacity cannot permit them to do that. Project finance is then considered in that regard. Sponsors with a limited balance sheet capacity, again, it comes down to capital. Where a sponsor doesn't have enough money to do a project, then they need this kind of financing from lenders to enable them to implement the project. And in situations where there's need for political risk mitigation, maybe it's an area that is quite remote, or maybe there's risk of war, some sort of political disturbance, then project finance comes in better. I hope you can hear me. I hear someone saying there's no volume. Okay. All right, I'll now proceed to the key features of project finance. Project finance is characterized by a special purpose vehicle. This is a particular company that is, okay, thank you. This special purpose vehicle is a standalone company that is created specifically for this project. It's mainly to implement a particular project that wants to be done. It could be a road that needs to be constructed. So the sponsors or the people who are bringing in the equity create this particular company in order to isolate the risks and the assets from the sponsors' other businesses. Project finance is also characterized by a long-term investment horizon where the funding maybe is going to take a period of 10 to 20 years to be repaid. That's one feature of project finance. Another one I had highlighted is the non-recourse or limited recourse aspect, where I explained that this implies that the lenders will only come after the project's assets and the income, but not the sponsor's wider assets. And this will encourage really the project to be successful. Another feature of project finance is the critical aspect of risk allocation. Because you're dealing with very many parties in project finance, it's very important to make sure that each party takes on a risk that they're able to bear, that they're able to handle. So project finance looks into that and making sure that the risks are properly allocated and mitigation measures are implemented. Project finance is also characterized by multiple sources of funding. In addition to the equity that is put in by the owners of the project itself, they will have the lenders come in to just beef up the capital that they have and enable them to actually put the project into action. You can also have banks and the development financial institutions come in to bring in the capital that is needed. I think we've spoken about senior lenders who usually provide the largest loans for such kind of projects. and they usually have a first claim on repayment. Then we have the mezzanine lenders who come in below the senior lenders, and they also have the ability to convert their debt into equity. Another characteristic of project finance is the leveraged security. Here, the security in this instance is the asset itself, as I'd explained, as well as the agreements related to the whole arrangement. You will have supply agreements, offtake agreements that I will delve into in the next slides. So these are also taken as part of the security to ensure that the lender knows they'll be able to recover what they have put in. The slide you should be seeing right now is giving a differentiation between project finance and corporate finance. I will briefly take us through this. So project finance, if you're trying to differentiate it from corporate finance, look at the aspect of recourse. Is the lender able to go for anything beyond the asset that is going to be implemented? Then that is not project finance, because project finance will only go for that and whatever else has been agreed upon. In corporate finance, we see that lenders will ask for all kinds of security. They might be giving you the money to set up a particular thing, maybe a hotel, and the hotel is on some particular site or land, but they will even want your certificates of title for other land that you own. They'll want a debenture, they'll want a pledge of your shares, so that is corporate finance. On the end of project finance, we have a more extensive lender risk. They are bringing in a larger chunk of the money here. Yes, the equity is there just to make sure that the sponsors have skin in the game, but the lenders bring in more money, so they take on a higher risk. They are looking at mitigating their risks, and that is what they do through the documentation. We'll also need to differentiate the kind of company that is dealt with in project finance and corporate finance. Now, project finance, you'll be dealing with this special purpose vehicle, something that has just been newly created. It's thinly capitalized, but in corporate finance, usually the borrower is a trading company that exists. There's a balance sheet that can be relied upon. There's a historical performance that can be referred to, so that makes it different from project finance. Another distinction is in the documentation. In project finance, we have more comprehensive and complex documentation because you're dealing with many parties, you're dealing with many lenders, you're dealing with risk advisors, so you need to make sure that the documentation goes through all the checks of all those people, and everyone is trying to make sure that they are protected. So the documentation is a bit more complex and comprehensive. While in corporate finance, I'm sure we've all dealt with the documents there, and they're quite standardized. You'll have the mortgage deeds, you'll have the debenture deeds, all those that are really very easy documents to come up with, and I'm sure we interact with them very often. In project finance, the fees are relatively higher because the lender is looking at a long-term investment in a project. So you will find that the fees are a bit higher compared to corporate finance. In project finance, there is also a longer term tenor. You see, these kind of projects are something that's going to take a while probably to construct. It could be a road. It's going to take some years to actually complete. So the loan is going to factor that into consideration and give a longer term so that the project company is able to enable itself to pay back the loan. I'll now take us through the typical project finance structure. I think you see the picture on your screen, which is showing you all the different parties that are involved in project finance. We have the special purpose vehicle, which is the particular entity that is established just for that particular project. And usually when we're advising clients, we advise that they make sure that the objectives of this vehicle are actually very specific and indicate that it has been incorporated for this specific project so that it doesn't then delve into things that are outside what is being financed. The sponsors are part of this special purpose vehicle, and those are the ones that provide the initial equity and usually just start up the company, and then they are able to bring on other lenders. We then have the lenders. You see them in the top right corner. These are the ones who provide the financing, the loans that are needed. Usually you'll have more than one, especially if the capital that is required is quite high. You'll have many lenders. So we'll get into a loan agreement with a special purpose vehicle, which details the agreed terms between the parties. In addition to that loan agreement, usually there's also an additional document, which is the direct agreement, which can be a contract between the lenders and the actual people who are going to do the contract, so that in case anything goes wrong, they're able to step in and make sure that the project is completed. We then have purchasers. I think you see them under the lenders. Those ones are the ones who are going to buy the output of this project. They're the ones who are going to, if it's water, power, this is going to be taken up by UETCL in order to provide power. So we'll have an off-take agreement, which is essentially entered into by the special purpose vehicle and the purchasers, just to make sure that there is ready market for the output of the project. We then have the operators. The operators are really the ones who are going to be implementing the project and making sure it's maintained. And an agreement is also entered into between the special purpose vehicle and the operators. We then have the contractors. Now the contractors are the ones who build this asset. So they sign a construction agreement with a special purpose vehicle, and usually that agreement has all the terms that have been agreed upon. It makes sure that it takes into account all the likely risks, maybe the delays that could occur, how those can be dealt with to make sure that the project is not failed by the contractor. We then also have suppliers. Suppliers now provide the input, the materials that are needed for purposes of the project. If it's a road being built, we have suppliers of bitumen or all the machines that are used on the road. So a supply agreement is usually entered into between the special purpose vehicle and the suppliers. We then also have insurers involved in this whole arrangement, because there's high risk in this kind of projects. You need to have an insurer to at least try and mitigate the risks. So those are also part of this structure. As shareholders and the special purpose vehicle also have a separate agreement executed between themselves to just determine how they are going to share the proceeds or the dividends that arise out of this project. Between the government and the special purpose vehicle, there are also agreements that are executed, one of which is a concession agreement. That basically is to give the special purpose vehicle the assurance that they'll be able to go ahead and implement their project. Maybe they're given exclusivity for some period of time, just to make sure that the project is ultimately viable. I looked at a few Ugandan cases of projects that are typically project finance, and one of these is the Bujagali hydropower project. This is one of Uganda's landmark project finance achievements. It's a hydropower plant. It was initiated in 2004, but took quite some time to be commissioned. That was achieved in 2012. Of course, there were challenges in the execution of the whole project. There were a bit of delays from requests that were made by lenders, but eventually they managed to conclude this. So this is a project finance kind of structuring. You look at the fact that there's a special purpose vehicle that was created. We have the Bujagali Energy Limited as a special purpose vehicle that was created. They borrowed money from many lenders to enable them to implement the project. The money that was mainly borrowed and syndicated by World Bank via the IFC and Africa Development Bank enabled them to actually complete this project. There was also political risk in this kind of project. This was mitigated with a World Bank partial risk guarantee and an implementation agreement that was executed by the government to cover any adverse circumstances that could arise. So this is one that we could look at and say it was a successful project finance case in Uganda. Another project is the 24 megawatt AMIA power solar project in West Nile. This was done by a project company called Ituka West Nile Uganda Limited. The financing was gotten from Emerging Africa and Asia Infrastructure Fund, and they also had other partners who provided support, such as the African Trade and Investment Development Insurance and the Regional Liquidity Support Facility. So the lead investor in this project was the Emerging Africa and Asia Infrastructure Fund, as I had mentioned. They had an off-taker, so the solar power that was generated from this power plant was taken up by UETCL for provision to the community around there. UETCL entered into a power purchase agreement, which is one of the documents I had highlighted. That's an off-take agreement, so that whatever comes out of the project is actually taken up, and you're sure that revenue is actually going to be generated from this project. Another project is the Nyamwamba Hydroelectric Project. This is in Kasese District. It's a 7.8 megawatt hydro plant, which was done by Serengeti Energy. Again, Emerging Africa Infrastructure Fund provided financing for this facility. Equity was also brought in by the sponsors of the project, and they managed to get into a power purchase agreement with UETCL for 20 years. So again, you see that the product actually already has someone who is going to take it up. So revenue is definitely going to be gotten unless something happens. And the security taken here included charges over the project assets, assignment of the construction and O&M contracts. And while there were issues with this project, which we'll discuss, there are always issues that arise in project finance. This one was affected by the COVID-19 pandemic. They had to stall for some time because of the challenges that arose out of that, but they managed somehow to finish the project. We'll discuss the challenges that really come up in project finance in subsequent slides. Another is the Kalangala Integrated Infrastructure Program, which is on Bugala Island. Now this one was a bundling of very many projects. It's not just the road that was done. There was a ferry service, there was power generation, and water supply. Now the island had been one that was really not invested in heavily by investors because of the situation around there. The roads were terrible, the transportation is bad. So the residents around there thought of coming up together and seeking funding. A special purpose vehicle was created, which was the Kalangala Infrastructure Services, and financing was gotten to enable them put together all these projects and implement them. Now this is a bundled kind of infrastructure project, a project finance project, because you see we have very many services that are provided. So the community benefited greatly from this. And also because of the diverse kind of services that are provided, they're able to generate more revenue, and that enables them to actually pay back the loan that was gotten. Because you have the ferry services, they're paid for, and that helps them in paying back all that was lent to them for this project. So that is one that we can also look at as an example of a project finance in Uganda. Now, to help us have a distinction between project finance and sovereign lending or finance, I also looked into the Karuma Hydroelectric Power Station. Now, this is not your typical project finance. I think you remember the slides where I was kind of differentiating between the two. While this can be seen as, yes, it's a project and it was implemented and there was money in it, but it wasn't project finance, rather more sovereign financing, because in this case, the government of Uganda borrowed money from China, the China Afri-Exim Bank, and that's the one that was used to finance this project and have it completed. Another one that helps us create that distinction is the Isimba hydropower project. Also that government borrowed money from China's Export-Import Bank and also contributed to the project. So when you look at agreements where it's a government that is signing finance agreements or loan agreements with institutional financiers or maybe international lenders, then there you see that is not project finance, because project finance has a special purpose vehicle, which is the one that gets into the arguments with all these other entities that I spoke to earlier. We'll also need to acquaint ourselves with the kind of documents that are common in project financing. Yes, there's the facility agreement, and I guess that can cut across board even for corporate financing. Now, this facility agreement really has all the terms that have been agreed upon. It has the interest rate, the repayment schedules, the security that is required, the covenants, the warranties, all that is encompassed in the facility agreement. We then also have a common terms agreement. As I had said earlier, project finance can involve very many lenders. So there are some agreements that have terms that are common to all of them, and that is all captured and put in a common terms agreement that can be referred to from time to time. We then also have an intercreditor agreement or subordination agreement. Now, these kind of agreements really are to determine how the various lenders are going to cooperate, how they are going to enforce in case they need to, in case of default, and that basically is what the intercreditor or subordination agreements cover. We then have implementation agreements, government support agreements, concessions. As we have all had, project finance needs a lot of backing from government, because someone is bringing in money, is putting in equity to put up a project that's going to take a while to have revenue generated. So they need that sort of assurance that they are going to be able to have this project succeed. And that's why we have the implementation agreement. That's going to make sure that the project is actually implemented after it's been completed, or government led some sort of support, or a concession is given to make sure that they have that exclusivity and they're able to actually generate the revenues that have been expected. We also have other ancillary documents in this kind of project finance. Of course, there are the usual security documents where land is being taken as collateral. We'll have the mortgage deeds. We'll also have direct agreements. There are fee letters, mandate or syndication letters, where we are dealing with many lenders and they need to appoint one maybe to be a lead arranger. So those are the kind of documents that are involved in project finance. I'll now discuss the risks that arise in project finance that we need to be aware of, and as we get into this space, we know how to mitigate them. So there's a completion risk, and this basically entails the fear that the project will not be finished on time, or maybe the cash flows will not be enough and it will stall for some time. Now, how this can be typically mitigated is through sponsor guarantees or fixed price kind of arrangements, where you make sure that in case something fails, there's someone, maybe the sponsor, who comes on board to lend more cash that is needed to enable the project to go on, or maybe it's a fixed price, there's not going to be a change in the prices of raw materials, that's not going to affect then the project being finished, or bring on technical advisors that are able to actually assess this risk from the start of it and actually advise on how the transaction should be structured. Another way to mitigate it is by providing for liquidated damages for delay. So then that is captured in the agreement, and the contractors know that there's a penalty for them either delaying or failing to complete a project. Another risk could be related to the site. A project can start and then you find that maybe there's a certain aspect and site conditions, maybe there's a rock that is hard to go through, or maybe there's some precious mineral in that area, or maybe you find that key materials are unavailable. So in that case, the way that this can be mitigated is by making sure that pre-construction surveys are conducted, and they're not just maybe done very recklessly. They should be given attention to, and the surveys should make sure that they are able to advise if there are any adverse conditions, how can then the project be rerouted or maybe something else done. Supply contracts also help in this case, especially with regard to the key materials that are needed. you get into a supply contract that makes sure that whatever is needed is going to be provided for the lifetime of the project. Engineers again also come in very handy for this kind of thing, because they are going to look at the site, they are going to look at everything and make sure they give a certification that this project is viable and it can go ahead. There's also a need for contingency planning. That can be one of the mitigations. Have a plan B in case something is found to be insufficient or there's an issue with a site. You're able to look into the next plan. Another risk in project finance is raw material supply and utilities. You could find that there could be supply disruptions, maybe prices change, volatility really is something that happens, or the essential inputs cannot be adequately accessed. And this again is mitigated with a long-term supply contracts, or maybe having a variety of suppliers that you can reach out to and make sure that you're able to get the product or the materials that you need for purposes of a project. Another risk is technology risk. Of course, with all these projects, there's need for some sort of innovative equipment or technology. Now, in some cases, such technology could fail. So the way to mitigate that is by requiring performance guarantee. So in the case of any failure, then the guarantees can be called upon, or provide for damages for any underperformance, have an independent technical review done, and also select providers of technology or equipment that have proven experience that will help to mitigate this particular risk. Another risk is the market. You could find that the project is set up maybe in 2010 and you're projecting that yes, there's going to be demand for power or demand for what kind of thing. Let's focus on power. But then you find that it goes down, the demand goes down, and then that is definitely going to affect the revenue that you expected or projected to get. And the way to deal with that, the insufficient demand, is by making sure that at the start of the project, you get into an arrangement where there's ready market for that kind of product that you're going to put out. Get into offtake agreements where possible. Have long-term sales contracts. Do studies on the level of demand so that your projections are actually accurate and you do the project having that in mind. Another risk is related to the permits and licenses. There are always delays in getting these licenses and regulatory approvals. It takes quite some time. There's always a back and forth between the government agencies. If you're dealing with power, the licensing can take quite some time. So to deal with that, of course, it will require a good legal team to help you to follow up and make sure that they're able to engage the relevant authorities to grant you the required approvals and the licenses. Implementation agreements with the government also help, because they help to make sure that the project is actually implemented, and they assist where needed to have whatever is stopping the project from progressing actually resolved. It would also be important to make sure that in the contracts, allocation of responsibility is very clear. Who has been charged with the duty of getting these permits and licenses? So then they have the obligation to make sure that they do that, and where they are falling short, then they can be put to task to make sure that they actually complete what has been assigned to them as their responsibility. We then have force majeure. Now, these are unforeseeable events really outside the party's control. It could be war, it could be natural disaster, pandemics, all that kind of thing. We know that after COVID-19, we kind of saw something that had not been envisaged. So now we have mitigation strategies where you make sure that the force majeure clause is more broad rather than restrictive. It's taking into account any kind of unforeseeable circumstances that could come, but then again not too broad as to make it seem that if a force majeure event occurs, then one can just rely on it and try to get out of something when they could actually be able to go ahead with a project. So basically how the force majeure risk is mitigated is by making sure that the contract expressly defines what it is, expressly provides for how it's going to be dealt with, and also making sure that the force majeure clauses across all the contracts are matching, so you don't have conflicting provisions that are going to sort of set back the project. We also have environmental risks here. These entail risks of contamination or pollution. How this is mitigated is that from the start of the project, make sure that the environmental assessments are done. Then, in addition to that, insurance also is very helpful because it can help to take cover of these kind of risks. Another risk is the currency risk. We know that currencies are volatile, and the dollar and the UGX keep changing. There could also be restrictions on transfer of foreign currency, which can impact cross-border payments. So how this can be mitigated is by encouraging payment in hard currency, or by encouraging the parties to open up offshore accounts, get into currency swaps agreements, and then also require government to give guarantees to sort of fortify against this risk. And also, of course, insurance helps to cover this. Another risk is the expropriation or expatriation of the project itself. You may find that the host government decides to seize the asset that has been set up by the project company, or they block repatriation of any profits that they get out of it. Now, how this is mitigated typically is by getting sovereign guarantees from the government, the relevant government in which the project is being implemented, getting political risk assurance. Again, offshore funds come in here because the funds can be taken out, and also getting into bilateral investment treaties that can help to make sure that the asset itself is protected from expropriation by the host government. Another risk that is common here is change in laws. Yes, the project has been done in 2010, but then maybe in 2013 we have an amendment of the law which affects the project. Maybe there's an increase in the rate of tax applicable. Maybe there's a change in the conditions of the licensing that is required. So that again is a common risk that arises in project finance, and that is mitigated with stabilization clauses in the contracts, or providing for compensation in case of any changes in laws. And also political risk insurance again comes in here to protect the parties. Political risk is one I have really highlighted. I will not belabor it. These are the wars, the civil unrest, the adverse government actions, and this really is mitigated with the insurance, with having a local investor part of the consortium. So there's some sort of participation of the person in the country. They'll have some sort of interest and help to make sure that any political disturbances are dealt with. Another risk is the collateral risk. You'll find that the asset, yes, is in Uganda. Maybe the lenders are from the UK, so they are dealing with enforcement of security in Uganda, and maybe they are not so familiar with the rules there. So to mitigate this, it's important that such lenders do legal due diligence that is robust. Make sure that you comply with all the formalities. As the Ugandan lawyers who are taking charge of the whole project need to make sure that you comply with all the formalities. If a mortgage has to be registered on a particular asset, the title, make sure that is done in order to guard against this collateral risk. Another risk is bribery or corruption, which exposes the project company to reputational risk or legal consequences that could be dire. We all know lenders don't like to have bribery involved, but maybe that's a bit difficult when you come to the practical side, because there's always some sort of kickback that is being given. But in any case, our role is to make sure that this is mitigated. In the contracts, insert representations and warranties that are typically saying that they undertake that they are not going to engage in any bribery, or they are not blacklisted, that sort of thing. Then also have compliance audits done to make sure that this obligation is being complied with, and if any corruption is flagged, it's dealt with decisively in order to make sure that the project is not hindered. Another common risk in project finance is the taxes, the inflation, the interest rates, which can keep changing because we know our fiscal and macroeconomic policies keep fluctuating. But how this can be mitigated is by making sure that the financial modeling from the start of the project takes into account these sensitivities. The financial advisors that look into the project at the start should factor in what if there's a change in tax, what if there's inflation, how is it going to look like if the project is maybe a hotel is going to be put up. The advisor should be able to assess how much are we likely to get if the economy is good and maybe uptake of the services is good, the rooms have full occupancy, or if they do not, what is the likely revenue that is going to be generated from this project. So also inserting inflation-adjusted contract formulas to be able to calculate, okay, if this changes, how is it going to affect the bottom line. I'll now quickly take us through the benefits of project finance. I think I've highlighted that project finance really enables the sponsors to raise substantial capital. You find that the sponsor does not have enough money to actually implement a project, but it's something that's good for the community, good for the economy. So with project finance, getting this lending from multiple lenders, they're able to actually implement that project. And then that really is one of the benefits of project finance. And then also there's the aspect of ring-fencing the project. The asset is typically the only security, so you don't have to be stuck and you cannot use maybe other assets or other kind of money that you have or security to get loans elsewhere. So again, also the financial obligations and the risk of the sponsors is sort of mitigated with project finance because the liabilities are only the asset itself or the project. The sponsors are able to go ahead and use any other sort of security they have to go ahead and get more capital or borrow so that they can input that in the project. Project finance also allows for flexible long-term repayment terms as opposed to the normal kind of financing. As I had said earlier, you'll find that there's a longer term that is given for the repayment. The repayment is tagged to the revenue that's going to be generated from the project. So then there's a more flexible kind of schedule, and that makes such projects more viable and gives it stability. The risk allocation in project finance is also one of the major benefits because the risks are taken on by parties that are best equipped to manage them. You'll not have one party take on something that they're not able to do and then a project fails. In project finance, the documents are scrutinized, the advisory is very robust, and the lawyers, at least, or the advisors who are involved in project finance make sure that these risks are properly allocated and they are managed properly. Project finance also mitigates the impact of sponsor bankruptcy or financial distress because they're getting all this funding, all these loans from multiple lenders. So they're also financially separated from the SPV, and then they're able to be protected from such kind of bankruptcy. While it has all these benefits and it's a good thing, we need to be aware of the cons or the disadvantages of project finance. As you deal with project finance transactions, you will realize that they're a bit time consuming, the documentation is complex, they're quite expensive, you're dealing with lenders from different jurisdictions, so each lender wants to have their own counsel in each country. You'll have English counsel on board, you'll have Ugandan counsel. So for the borrower, it's quite expensive because they're going to be requested to pay all this money. Or if you're bringing on other lenders and that whole sort of arrangement, the arrangement fees are going to be quite high. So that is the expensive aspect of project finance. Time consuming because it requires a very extensive review. It's a back and forth. You have different council lenders looking at the documents and getting back and having meetings. So it takes quite a while as opposed to any other kind of financing, which can really be done in a shorter time frame. The documentation, as I'd already highlighted, is quite complex. You have all these kind of agreements, the offtake, the implementation agreements, and they can be quite a bit much, and there's a need for coordination with multiple third parties. You have the ministries maybe looking at the documents that are being generated. They have to go through approvals. They have to get legal opinions. Then the documents with the off-takers, they also have to review and confirm that they're able to actually take on what is being given to them. So the documentation in project finance is also quite burdensome, but of course as lawyers, I believe that is something we are used to, and it's something that we can manage. Project finance is also characterized with limited flexibility because you have long-term offtake agreements. You have restrictive loan covenants that really are designed, of course, to protect the lender's interests, but then they limit the flexibility because the sponsor or the project company is quite limited on what they can do in undertaking this project, and that sometimes can stifle their ability to attract more capital. There is also all the significant risks that I had highlighted in other slides. Maybe completion could fail to get achieved. Maybe there could be political risk. All these risks really arise in project finance, and this is something that is being done for a period of so many years. So it's not that the revenues are going to be generated in a short time and then it's up and running. It takes quite some time. The equity returns also, because the sponsors have come up and set up this SPV and they intend to have some sort of dividend come out of it, but this can be affected because of the length of the project finance, the documentation, the cash being trapped in reserve accounts, or maybe there are restrictions on payment of dividends. So for the sponsors themselves, they might find that this sort of project finance arrangement is a bit stifling, rather than if you're a normal lender, a normal company, you go and borrow money from a bank and you're able to give them certain security without actually stifling your ability to get dividends. So these are the cons of project finance, and we need to be aware of them as we are advising our clients on whether they should opt for this kind of financing. But again, because of the benefits, maybe it's something we can consider giving them as an option. I'll now take us through the major challenges in project finance. Yes, as I already said, this is something where we have a special purpose vehicle that is set up, and they bring in some bit of equity, and then the lenders bring on more money to enable them to actually implement this project. So you see, in doing all this, there's a lot that goes into it. Let's talk about the need to acquire land for a project. If you're going to set up a dam, if you're going to set up a hydropower plant, you're going to need to acquire land. And in some instances, you find that there's a lot of back and forth. Maybe the people in that area are not willing to actually give the land. There's need for compulsory acquisition, and that all affects the kind of transaction, the project financing. There are regulatory bottlenecks, there are delays. Maybe there's that whole, we have a land tenure system that prohibits foreigners from having land that's under my law, so they have to do the conversion into leases. So that can really take a bit of time. There's also the need for land to be registered. Maybe you're dealing with land that is under customary tenure. You have to make sure you get a title, because most lenders will want to have titled land as the one on which the asset is going to be put. There's also complex permitting processes. You need to get all these licenses. That again can take a bit of time. So those are part of the challenges in project finance. The other challenges I'd highlighted as part of the risks I discussed, we have the foreign exchange currency risks that come up, the political risks. Those again can be mitigated. Of course they can, but they always come up as challenges, and they can fail a project, or they can make a project delay because of what has to be done in order to resolve the issues that they cause. We also find that there's domestic debt capacity, which in Uganda is quite limited, so we need international partnerships for project finance, and you see they come with their terms and conditions, which can be quite difficult at times and require a company to just sort of really unravel itself and try to make sure that it is compliant and meeting the standards of these international lenders. So that again is really a challenge in project finance. The legal structures can also be quite a challenge, and the governing law, there's always some sort of discussion about which law should be applicable if the project is here in Uganda, but then the money is being gotten from international lenders. Of course, their preference is laws that are in their country, and then also here we are trying to push back for our Ugandan law, and so that sort of struggle, I guess, of power on the governing law can also be quite a challenge. There's also complex structures at times that are involved because you're dealing with so many parties. There's a lot to take into account. There are so many moving parts. So there's a lot of maybe attention and detail that goes into it, which can make that kind of project finance transaction quite onerous. There's also a challenge in market volatility. Again, as I say, the project is being set up with the expectation that revenue is going to be generated from that project, and then the project company is going to be able to repay the loan that has been gotten from that revenue. But then if there is market volatility, if there are changes in prices, if there's a change maybe in policies that affect the kind of pricing that is given, that is going to be a challenge, and it will affect the outcome of the project finance project. The success factors, or really the things that we need to make sure are in place to make sure that our project finance is successful. We need to make sure there's a long-term off-taker agreements. Again, emphasis on the fact that the loan is repaid from the revenues that are generated from this project. So you need to make sure that these revenues are actually assured. And how is this done? By having an off-taker ready to take the output of the project, enter into PPAs, have government contracts entered into, implementation agreements, that sort of thing, to give the assurance that the project is not going to be a false start. Another factor is thorough due diligence and robust documentation. That goes for us, the lawyers. It's important to do the due diligence. If land is being acquired, know what kind of tenure it is, advise the clients appropriately, know if there are any issues with the asset area, if there are any caveats, if there are any site conditions. Of course, that's for the engineers. Doing that due diligence is going to make sure that any risks are flagged early on in the project and they are actually mitigated. The robust documentation is important because it will help to make sure that all the holes are plugged, all the risks are taken into account, and the documentation makes sure that the clauses in there are protecting all the parties. Another essential factor for success is capable management. This again comes to the management of the project. The project company should make sure that the people who are in charge of it, the contractors they get on board, are actually people who are able to manage it and to make sure that there is no waste being done. And to take on a contractor that's going to end up failing to complete the project because maybe they have issues with URA, or they actually don't have the experience that they said they had when they put in a bid. So that due diligence on the contractors is important to make sure that the people that actually you get to implement a project are people who are going to be able to complete it and make it successful. Another success factor is really the financing. It's a major factor. Blended financing, have the commercial banks come in, have development financial institutions. Donor grants are also quite important for project finance to be successful, because you'll have all this money coming in and it's going to allow the project to actually move fast enough, get completed, and then we start reaping the fruits of this project. Strategic government and development partner support is also a critical aspect of project finance. In order for it to be successful, you need to make sure that the relationships with the stakeholders are managed, relationships with government are smooth, because you'll need to engage them from time to time. And if a project really has is blacklisted, or there's a problem actually going to yield and going to succeed, because there's issues with it and the actual strategic partners who are needed to make sure that it is successful. Risk management, again, I must emphasize that risk allocation is a very important factor in project finance. The risks need to be met by those who are able to actually meet them. So for a project to be in the Ugandan space, of course, we have all the other international lenders. We have World Bank that can provide the funding that's needed for project finance. We have the IFC, we have Africa Development Bank, but I looked at the Ugandan context as well, and the major banks that we could look to as lawyers, maybe we are seeking business in this space of project finance. One of the banks is Uganda Development Bank. This is really a development bank, and it actually provides this kind of finance solution. It gives long tenors or this kind of loans. Again, also them in this kind of solution, they are looking at the projected cash flows. They are focusing on the financial viability. So maybe as lawyers, we can position ourselves, get ourselves acquainted with the kind of products they give, advise our clients on this kind of availability, and also get into the space with UDB, advising them on how to structure their documentation when they are dealing with project finance. Another local entity that we could look to is the East African Development Bank, which also does a lot of project financing. It's also a key regional player, and their focus for EADB is mainly on socio-economic impact. Yes, they'll give these loans, and they're giving them out for manufacturing, for agro-processing, tourism, construction, and the aspect of assessing the project feasibility is also a critical one that we need to actually be aware of. You will find that, yes, an application is going to be made for a loan for project financing, but these lenders are going to really look deeply into the documentation of the project. They are going to assess the viability of the project. They are going to assess the sponsors. Are these legit people? Are these people who are going to be able to pay us back? Is this project one that's actually going to generate revenue? I mean, we see the Kalangala project, yes, will generate revenue. The hydropower projects will generate revenue, yes, but they need to look into all that and assess. If a project is found to be unsuitable, it's not going to be given the project financing solution. To cap up this discussion, I'll also just quickly run through the opportunities that are available for us as lawyers, how we can position ourselves for these opportunities in project finance. There is need for lawyers, really, because you're dealing with transactions, you're dealing with documentation. We need to advise clients on how to structure the documentation, to negotiate the terms. Again, the preparation of the documents is our job as lawyers. So we need to equip ourselves with the knowledge to actually be able to handle all this. Conducting the due diligence is also a role of the lawyers, assessing the risk, making sure that the project is in compliance of all the laws, checking that all the obligations are being complied with. Again, that is an area that we as the lawyers can position ourselves for and advise customers in this space. We can also support the sponsors, the lenders, and the government agencies, particularly with the licensing aspect, the land rights, helping them to get all their land documentation in order. If any titles have to be processed, that is something that lawyers take on. Another thing is the dispute resolution. Of course, disputes will arise. You're dealing with very many parties in project finance. They are bound to have some level of dispute. So we need to position ourselves to advise. Usually they will favor arbitration, so maybe equip yourself in arbitration and just be positioned to be taken on as an arbitrator and advise on how disputes can be resolved. We also need to be aware on how to advise on the risk allocation, the contract enforcement. And again, as lawyers, this is a space where we are interacting and collaborating with very many other lawyers. We need to be able to collaborate, could I say peacefully? You need to be able to look at the end goal. What are we trying to achieve here? We want a project that's going to be successful, that's going to be sustainable, that's going to generate the revenues that have been envisaged. So we need to make sure we are working together for the success of this project. Sometimes you'll find that you're dealing with lawyers and maybe one is trying to show their power. They are advising maybe a contractor, so the lender could ask for something and this other lawyer refuses, but yet it's something that's not really going to affect anything in the grand scheme of things. So I think my advice would be for lawyers to collaborate in this space, because we should ultimately be looking at the goal of the project, which is to have it successful, but then again making sure that we are mitigating the risks and protecting the interests of our clients. Thank you for listening, and this brings me to the end of my presentation. Thank you.
Thank you very much, Patricia, for that great presentation on project finance, which has brought us to the end. I don't see any questions in the chat regarding the presentation. I will presume that we have understood, but okay, I see someone is trying to ask on the chat, but maybe as we wait for the question to come through, I know you have touched on this, Patricia, but maybe to just delve deep into it, especially on the geopolitical risks. We have seen particular countries, South Africa, for example, that have heavily had a policy shift, terminating their bilateral investment treaties. How are you, or how are people in the project financing space addressing those particular geopolitical risks, especially given that given African countries' attitude towards investment treaties?
Okay. Thank you. Now, how the geopolitical aspect can be dealt with, or how it's being dealt with, first of all, is encouraging staying informed. It's good to be aware of what is going on in all these other jurisdictions, because that's going to inform the kind of advice that you're giving to your clients. So staying informed is one of the ways. Also developing a risk assessment protocol that can help to keep in mind the risks that are arising and being able to mitigate them. Advising clients on what needs to be done in light of what is happening in one jurisdiction. That can also help in dealing with the geopolitical situation. Again, it also comes down to the documents that are done at the start. The documents need to take into account those kind of risks, and if the documentations actually do that sufficiently, that is going to be a problem that is easily resolved.
Thank you very much. Maybe also the last one from my end. I know you have talked about this as well, but maybe again to just re-explain for our online community. Post COVID-19, how are you or the people in the project finance space structuring clauses to at least ensure project continuity? And specifically, I know you've touched on force majeure, but how are those clauses now looking post COVID-19?
Okay. Thank you. So before COVID-19, really, we're not looking at situations like that. It was kind of a novel thing that happened. So after it happened, you find that many contractors were now failing to continue with the project because maybe there are lockdowns, or they can't move, there are restrictions, and they're not able to actually find a solution because the contract they entered into did not factor in force majeure. So now how it's dealt with post-COVID-19 is that the clauses have been made more robust, more inclusive of this kind of risk that could arise, provide for pandemics in the force majeure definition, make sure that the definition is exhaustive, it's catch-all, and then in that way you're able to have all those kind of risks covered in there. And then also, again, it's important to make sure that all the documents, because you're dealing with very many different documents, you might change the force majeure provision in one clause and forget to change it in another. So you find that you're in a difficult situation because of that. So now, post-COVID-19, you're trying to make sure that the clauses that are put in one argument are actually rolled out, and that kind of back-to-back clause is implemented all through the arguments. Yes.
Okay. Thank you very much, Patricia. We see there is a question from Spera Nwomugisha, who says, how should we address the issues that arise during negotiations, especially hidden clauses in documentation? How should lawyers take in to identify these?
Thank you. Hidden clauses. I think that really comes down to the due diligence, the level of attention you're giving the documentation. Yes, it's bulky. You'll have implementation arguments of so many pages. But because the devil is in the details, it's important that you read each of these clauses, because you could miss out one thing, and that is what unravels the whole transaction. So I think the answer there would be to encourage that level of scrutiny to the documents. Yes, they might be bulky, but as lawyers, that's something that we chose to deal with, and to avoid encountering such hidden clauses, it would be important to really pay attention to all the details in the documents. Don't just do a cursory read of the arguments, but really do a deep dive and try to appreciate all the clauses and their meanings and implications.
Okay, thank you very much, Patricia. I don't see any other questions in the chat, so I will then bring this particular session to a close. Thank you very much to the online team for staying with us for these 2 days of the Banking and Finance Symposium. I hope we have been able to learn a lot from this session and yesterday's sessions. And yes, have a lovely day. I have been your host, Belinda Patience Cheptowek. I am an associate with Signum Advocates, and see you next time. Thank you.